Rise. Hey, all persons of any to before the honorable justice of the appeals court. Now shall begin law and law within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honors.
Good morning. All right, good morning, everyone, and welcome to today's sitting of the Appeals Court. I hope everybody stayed warm this morning, and we'll do so for the rest of the day. The panel today consists of myself, Ariane Vuono. To my right is Justice Suk-Young Shin, and to my left is Justice Paul Smyth. We have a full day today. We plan on taking our break after case number 4. I see people here who have argued before us previously, but I will remind you anyway that you each have 15 minutes. We've reviewed everything that you've had submitted to us, and so therefore you can get right to your most important points. And I always like to remind everyone that there's no rebuttal in the appeals court. So after you make your argument and you sit down, we will take that portion of the case under advisement. Okay, with that said, the first case is Commonwealth versus GERALD BOWENS. Is that correct, Bowens? All right. 2024-0213. Good morning.
Good morning, please the court. Adriana Contratesi for the defendant appellant, Mr. Bowens. I took this case over from previous appellate counsel who wrote the brief. And in the first issue, appellate counsel wrote that she thought that the contention was that the videos had a meager probative value. Boy, is that an understatement. Those videos had no probative value at all. When I sat down to watch those videos, I was appalled and distressed. And then
the video of the altercation, would you say that's not probative?
Well,
I mean,
and I do. Let me correct myself. I'm not
what are you talking about
right.
precisely?
I'm talking about the remaining 14 minutes that the jury watched.
You're talking about after the victim has collapsed on the ground?
Collapsed on the ground, and the defendant has run away. The fight is over. The issue was, did he act in self-defense? The jury then watched 14 minutes. I think 14 minutes is my number. Maybe my brother or sister will correct me later on. But 14 minutes of the victim dying an agonizing death. And I don't know what probity it had. Now, I know that Judge Allman did say that it was relative to sequence, timing, extent of injuries, and the element that caused the death. But I'm not finding that.
Let me ask you a question. Let's say hypothetically we were to agree with you that the last portion of the videos, and I'm referring mostly to the Exhibit 1, the composite, because that
the composite, yes,
is the easiest way to
Correct, yes,
review it.
thank you.
All right, it is not relevant once the EMTs arrive. Let's put a place marker right there. All right. Here, the judge did follow Walters, did go out of his way to mitigate any potential prejudice, recognize the graphic nature of the videos, of course, was familiar with them from the first trial that was in a mistrial. So could you tell us why that was not enough? Why this case is different than what the SJC said was sufficient in Walters to mitigate prejudice?
Well, the first thing, in the Walters case, that was a first-degree murder case. And those were still photographs in the Walters case. And also, the evidence against Walters was very, very strong. So even if while they found that the photographs of the bulging eye and everything were error, what had happened 6 days previously when Walters did the killing, that the evidence was so strong.
What I'm getting at is that there were certain precautions that the judge took in that case. The SJC said that it was prejudicial and should not have been admitted.
Yes,
so that was that part we know. But there was the precautions that were taken by the judge to mitigate the prejudice. The voir dire, for example, of the jurors, permitting the jurors to view the videos on their own, so to speak.
Yes.
Limiting the publishing of the videos, not permitting the still photographs.
Right.
In your view, of course, that was not enough, right?
Well, but the jury
and
had
why is
everything.
that?
Because the jury had everything. And not only did the jury have everything, but this composite was played more than one time. It was played and paused. Let me see specifically. It was Mark Murphy from the Boston Fire Department. A little bit was played. He gave some commentary. It was paused.
Yeah.
Then he gave some more commentary. A little bit more was played, and then it was paused. A little bit more, and then paused. So that kind of additional commentary is really powerful, but playing it and pausing it and playing it and pausing it, I think that it's so inflammatory. Besides the fact that it went into the jury room with the jury, and one of the things that happened in closing argument was counsel specifically encouraged the jury.
Yeah, twice to watch frame by frame, yeah.
Not only to watch it frame by frame, but to stop it, to reverse it, to watch it again, to pause it, all these different things. I have the exact site as
But that, of course, all could have been referring to the critical issue, which is whether or not your client acted in self-defense, an issue that the jury grappled with by virtue of their questions, you can see.
Yes, they
Right?
did grapple with
So
that.
I'm not so sure that the closing argument that you're pointing to right now necessarily went to the prejudicial nature of the videos. Could just as well have gone to the other issue in the case.
Well, if it could have gone to the self-defense part of the case, how can you make an argument that it didn't, that it didn't go to the other part of the case in the jury's mind? And this would have been different.
I think you agree that the altercation, the actual physical fight, of course, was relevant and properly admitted.
Well, that was the issue, was that self-defense, yes.
Is the argument, counsel, that unlike Walters, the instructions here were not as robust?
I'm sorry, Judge, I didn't.
Yes. Is your argument that you would distinguish Walters and that it appears in Walters there may have been contemporaneous instructions, there may have been multiple instructions, but your argument is that in this case, the instructions as to potential prejudice, the inflammatory nature of the videos, the instructions weren't sufficient. Is that your argument?
The instructions weren't sufficient. That needed to be limited. That needed to be severely limited. Watching somebody die for 14 minutes, how is that relative to whether or not the defendant acted in self-defense? We have the entire fight on video. I think all the rest of it is just, it's very disturbing and very inflammatory. I think it would be very difficult to watch somebody suffer like that and not hold that against the defendant. But also, again, in Walters, we have a first-degree murder case. The body was 6 days old. There were only still photographs, and the evidence of the defendant having committed the homicide was very strong. I just don't think that this is so not comparable to Walters.
You're saying because the issue of self-defense was not strong? I mean, what do you mean? In this case, of course, the entire altercation and the stabbing was recorded. So
it was, but it wasn't. The defendant never contested that he did not. That he
the
was
weakness
not
you're pointing.
responsible for
The
this.
weakness you're pointing to is whether or not your client acted in self-defense. That's what you're saying.
Yes,
Is that right?
and
Okay.
in Walters,
All right.
they were trying to prove the killing, so it was a totally different thing. And that, I think, is why, even though those grisly photographs, the court found that they were not probative or not necessary, and they were error and abuse of discretion, that the judgment was still affirmed because there was plenty of evidence that he had committed the murder otherwise. We don't have that here. We know that the defendant had done the homicide. He admitted that. So how does watching?
Well, I think his point was it was a justified killing, that it was not a homicide. Is your client's position correct?
That it was in
Yeah.
self-defense,
Yeah.
yes. Well, it still wound up to be a killing. But yes, the defense was self-defense.
Okay.
So, and that's an affirmative defense, so he did admit that. It wasn't a live issue. So I don't understand. I think it would have been different, too, if this had been an issue where the Commonwealth was trying to get an instruction on extreme atrocity and cruelty. But we just don't have that. So it was very inflammatory. And the next thing I wanted to mention was the second issue that that was presented, was that the closing comments inferring that the Commonwealth somehow had inside knowledge of what the defendant's motive was in doing the killing was not only was it prejudicial, but it tied into the inflammatory nature of the evidence that really the jury should not have seen, which was he was doing this to uphold his reputation, not to act in self-defense. And there really wasn't any evidence that that was his purpose in getting involved in this altercation. The reason why he got involved in the altercation was that the victim stabbed him in the head.
Okay.
What was there evidence that there was a dispute between the victim and the defendant's girlfriend?
Oh, there was plenty of, well,
But it wasn't related, your point is it wasn't related to the evidence that the defendant carried a knife because he dealt drugs?
no, it was nothing like that. So I do think that was, I know that this was a difficult case. There is absolutely no probative value. This is strictly a 402 problem, 403 problem. The jury did not need to see 14 minutes of somebody dying a very gruesome death to determine whether or not the previous 6 minutes was a self-defense issue. So based on that, I think that the defendant is entitled to a new fair trial.
Okay.
If there are no other questions, I'm happy to rest on my brief.
Thank you very much. I see no questions.
Good morning. May it please the Court. ADA David McGowan for the Commonwealth. With me this morning are ADAs Sarah McAvoy and Alexandra Rahimi, the trial lawyers in this matter, both the first trial and the second trial. Beginning with the first issue, the admission of Exhibits 1, 35, 37, and 45. There's a kind of a wonky standard of review, as 2 of them were objected to so much of the video.
Right, we saw that. We can
Okay.
follow that. Why don't you tell us why and how the last portion of that video was relevant to any issue in the case?
Well, it's relevant in this case. I think, as my sister points out, if this were an extreme atrocity case, this wouldn't be a colorable issue on appeal, but of course it's not.
We're not there. It's a manslaughter case.
The evidence, as Judge Ullman indicated, is relevant to both identification, which the later part isn't as important.
Excuse me, stop right there. Identification.
Of the defendant.
How was that an issue in this case?
Until the defendant testified, it's always a live issue. In this video, it identifies who is who in this fight on the video initially is incredibly important.
Let me be clear, I'm talking about the last portion of the video?
He leaves. It's for the initial part for identification, and the defendant leaves. So
Okay.
that video,
I don't think that there's much question about the showing the actual altercation, the physical fight between the 2 people. What I'd like you to address is how the last portion, when the EMTs are administering emergency aid to the victim, how that's relevant. It doesn't have anything to do with identification. Would you agree with me there?
Correct.
Okay.
It goes to the extent and severity of the injuries. And in this case, that's relevant because there's no dispute that the victim initiated this with a swipe to the defendant. That's captured on video, not in dispute. Where the defense is self-defense, and the Commonwealth has to establish that there is excessive use of force in that, at least initially, justified self-defense, the extent of the defendant's actions and the injuries and how they caused severe injuries immediately. This is separate from Walters with the passage of time, as my sister pointed out, days later. This is moments. This is not an hour-long video. This is not 3 hours. This is mere minutes.
Was it a full 14 minutes?
Mike, I want to say
Do I have
it's
to
8
watch it
minutes and
again
22
to
seconds.
figure that out?
Exhibit 1, the compilation, which arguably is the most graphic, I think on the scale of things that the court has seen over the years, probably not terribly gruesome, but it is not great video. It's uncomfortable. My count is 8 minutes, 22 seconds, but that's,
Okay.
there are 4 exhibits, cumulative and then compositionally. Some of the other complained of video, which does capture post-defendant's flight and maybe post-initial civilian aid, captures none of the gruesome aspects of this case. But what it definitely underscores is the ability to flee. So what the defendant, before using this self-defense, and initially justified, the victim displayed a knife and swung it at the defendant, arguably and inferentially causing minor injury to the defendant's head. The avenues of retreat are extensive. The video depicts the victim falling and the defendant setting upon him for some period of time, being surrounded by what looks like people familiar with both individuals, not rendering aid, just observing and then fleeing, leaving the area at the same time the defendant did. The severity and extent of these injuries, and while not comfortable to watch, the rapidity of decline, the difficulty to render treatment, goes to the extent and the severity of force used by Mr. Bowens, initially defending himself and then seeing through to what ultimately was a homicide. I don't think this is an easy call for any trial judge, but as the trial judge, as the gatekeeper of these, is required to perform a gatekeeping function. And here, under Walters, the judge carefully, in both trials, reviewed the evidence and gave certain limitations to the Commonwealth's use of this evidence. One, permitting nothing to be published to the jury after the moment that defense had objected to its inclusion, and that was left for the jury, if they wanted to review it during deliberations. No still photos used from this video. There was one introduced, I believe it was Exhibit 13, but no other still photos from this video were to be used. Civilians depicted in this video identified themselves and explained their conduct as relevant to this case. The judge gave important instructions during impanelment, so each juror that was sat in here was vetted for their ability to maintain an impartiality and balanced assessment of the evidence despite the potential of seeing difficult evidence. And then at the conclusion of trial, that instruction was reiterated. And Justice Smith, you mentioned there was not a contemporaneous instruction, and there was no objection to the lack of an instruction at the time. And that, I don't think, damages the Commonwealth's case on appeal now, because it calls attention to the graphic nature of it. In fairness, the part that was most graphic, complained of by the defendant in pretrial hearings and at the time of admission, wasn't played. And so to give the instruction and then not publish the rest of that portion, I think arguably is awkward. And so in calling attention to something that is not being shown to the jurors that they may never choose to review.
I'm sorry, which portion wasn't played?
So the Exhibit 1 was introduced.
Yeah.
So it's entered into Exhibit. When the Commonwealth published it, so much of the video that, as Justice Vuono was describing, of the defendant leaving and serious medical aid was being rendered shortly thereafter, was not published. So the Commonwealth did not play that exhibit in its entirety in front of the jury. And so there's no evidence other than the exhibit being sent back with the jurors that the jurors ever saw it. But the inference is that they had it and they reviewed all the evidence.
There was some portion of that played during Murphy's testimony. Is that not right?
A video, a still.
I'm sorry?
A still was used with the firefighter.
Okay.
It's a still image. I believe it was Exhibit 13. Sorry, Exhibit 3. I had one of the numbers. Exhibit 3 was a still photo. So I don't believe that video was played for the firefighter and certainly not to any lengthy extent. The Exhibit 1 was not played from start to finish. And that was the judge's thoughtful limiting, and under Walters, expressly discussed Walters in his evidentiary ruling. And further, the fear that this is so inflammatory and so gruesome that it would kind of tip the scales and been an unfairly prejudicial. I mean, all evidence is by design prejudicial, but the conclusion that this is unfairly is belied by the trial record in this case. All of these video exhibits were introduced in the first trial, and as the court knows, the jury struggled to reach a verdict and could not reach a verdict despite that evidence being admitted.
How is anything that happened in the first trial relevant as to what happened in the second trial?
Because the judge, having seen that, is reviewing his evidentiary rulings the second time. The Commonwealth, knowing that it was a difficult case the first time, did not try to press its perceived advantage of the gruesomeness, did not seek to change how the evidence.
You're saying that less was shown in the second trial than the first trial?
My understanding is both trials were exactly the same in terms of the presentation of evidence.
Okay, so
So
what do you mean by not pressing then?
it was a difficult case where the jury could not reach one the first time. The same evidence was used. So the idea that the evidence is so inflammatory as it would cause the jurors to use emotion to reach a verdict against the defendant is not really rooted in the record. First jury couldn't agree. That's not part of what this court's
I see your
reviewing.
point.
But in this case, as the judge is reviewing and performing his 403 gatekeeping function here, he's aware of that trial. He was the judge of the first trial. The Commonwealth, likewise, is pursuing its case in the exact same fashion, not trying to highlight gruesome parts, following the court's rulings, in fact, assisting the court in proposing different ways to mitigate under Walters how this evidence should go in front of the court. And I think to take that careful analysis that's on the record and deem that an abuse of discretion is truly difficult.
I'm sorry, I just want to clarify. So during Murphy's testimony, Exhibit 3 is published, and then Exhibit 1 is played. I'm looking at transcript 3, page 85. So it's played beginning at 5 minutes, 18 seconds, and concludes at 6 minutes, I believe, 22 seconds. Wouldn't that capture some of the
It must have,
portions?
and I may have missed that in the statement. My reading of the transcript is that's not dwelt on terribly long. So the aid being rendered by the firefighter, I think is not error under the careful analysis. If this court were to conclude that that portion, and I think reasonable trial judges could disagree on that admission of this piece of evidence and how to handle it. But that difference of opinion doesn't make it an abuse of discretion and from jump a prohibited piece of evidence. But if this court were to find prejudice, or that was error and somehow, it's difficult to find prejudice, especially under the Walters analysis. That is certainly an extreme case. Many of the cases that find error here are extreme. There was one of cited Richmond, especially gruesome, where an animal had attacked part of the body. This is not terribly gruesome. It's incredibly important to the Commonwealth's case as the jury is evaluating the extent to Mr. Bowen's self-defense. And under most cases, there is a dispute as to who the first aggressor is. Here, that is not in dispute. So the extent of Mr. Bowen's self-defense and the damage he caused in response to a knife being waved at him and a small laceration on his head is incredibly probative of the extent of whether his self-defense was excessive.
Well, if we grant you that, though, let's just say we agree there's 8 minutes of video after the defendant left the scene. So why is minute 8 still probative and not overly prejudicial as compared to minute 2, if you're trying to prove the point of the nature of the injury?
Because the inference is that the jurors see Mr. Bowens expire. I think if Mr. Bowens then survived for 2 days in the hospital after that, I would have a much harder argument. In this case, they're seeing...
But that's not disputed.
But until the Commonwealth rests, we have the burden of proof and the burden of persuasion. And so not knowing whether the defendant would testify again in the second trial and what the defendant would say, we can't rely on what is in dispute or not until that happens. And so...
I think the point is that the fact that the victim died is not in dispute, right?
No, but how...
And then he died there from loss of blood.
No, it's not terribly in dispute. It's whether the extent of self-defense. But if this went on for much longer, much harder case for the Commonwealth. If this were an hour video where he expired later, you can inferably see Mr. Bowens pass away in an 8-minute video. So to trim out the last 2 or 3 minutes, I think that robs the jury of probative video evidence, not the cold doctor on the stand from the Office of the Chief Medical Examiner describing in really difficult terminology and vocabulary that isn't familiar to the general public, generally speaking.
Yeah, those jurors get that kind of information all the time in most cases. It's not...
They
right?
do. In the cases that we have, it's difficult to rely on them for that element. It's generally cold and it does, in theory, check the box in a sufficiency analysis, but whether it gives the jurors a sense of whether Mr. Bowen's behavior was extreme and excessive use of self-defense, the location of the wounds and the damage it caused and the rapidity of the damage, especially in light of, so that's, the judge made that evidentiary ruling during the Commonwealth's case in chief. Then the defendant testified, which I think, to the degree there was problems with that evidence, was further mitigated by his explanation of, from his point of view, how this went down. The holding a knife in his hand was kicked by the victim, and it was merely a scrape. I had no idea I caused that damage. The video takes on an additional probative aspect at that stage in the trial. And while the Commonwealth submits that this evidence was properly vetted by the trial judge and carefully limited in a reasonable way, even if this court were to find error, to find that reversible in this case, I think makes the vetting process of this evidence very difficult for trial court
You
justices.
want to say anything about the closing argument? Because you're just
I would.
about-
I think the Commonwealth rooted all of its evidence from start to finish in evidence in this case. In particular, the complained of portions of the prosecutor's closing here was rooted in the defendant's own testimony, that he came to the area, he sold drugs in the area. He rode his bike there and sold drugs for 8 to 12 hours a day. He chose to arm himself by buying a knife at Home Depot, and he carried it with him, not only because the area was dangerous, but because dealing drugs in the area was especially dangerous. And as the video shows the cluster of people in the group that they were operating in, as the record establishes different confrontations, allegedly with a bat, allegedly with arguments with girlfriends, the defendant arming himself and defending himself immediately is relevant here in the rationale for why he did that. Whether the jury credited it, it's hard to say. What the jury focused on, as the Commonwealth pointed out and directed them to the video, was the conduct and the excessive conduct. The Commonwealth did not highlight in any way in closing the firefighters' efforts, the civilians, the extent and the complained of portion of the video. The Commonwealth was focused on the defendant's conduct here from start to finish.
Right.
The justices have
I
no
don't
further
see
questions.
I don't see any further questions. Thank you both very much for your arguments.
Thank you.
Have a good day. Right. The next case we have on the list today is impounded, so I remind the parties of that. Department of Children and Families versus another and versus the mother and another, 2025-0476. And just to confirm, we have a split on the appellant's side of 10 minutes and 5 minutes.
That's correct, Your Honor.
Thank you.
Thank you. May it please the court, Eric B. on behalf of the mother. First, I'd like to mention what this case is not about. There's no evidence of drug use, substance use. Mother had no criminal history, and mother had, although there was testimony regarding domestic violence with the father, the mother left the father, and so that was not an issue in this case. The central issue in the case really was mother's mental health. She had a diagnosis of bipolar disorder, and her efforts to address her mental health issues. DCF did not have any concerns about her ability to provide basic care. In fact, she was a very capable mother in many respects. And I also would highlight for the court the mother's relatively young age. She was in her early 20s when she had the child and did not receive the mental health diagnosis until after the child was born. In fact, until after the mother had fled to the domestic violence and come to Massachusetts. And as Dr. Carbone, who is the psychological evaluator, testified, it's not uncommon. In fact, it is typical for patients who have this diagnosis to take some time to deal with it and to get on board with medications. And I think that's reflected in the record here. And again, given mother's relatively young age, she did struggle with accepting the medications. But I submit by the time of trial she had, and I think that evidence is fairly uncontested based on the testimony of the evaluator, mother's prescriber, and the mother herself. The real question in the nub of the case is the trial court's determination that even though the provider said mother was on her meds and mother hadn't had a hospitalization for several months before trial, and the mother said she was committed to taking the medications, the trial judge said, I don't believe it. I think there's a pattern here, and I think that the mother will at some point decide to stop taking the medications and decompensate. And I submit that the evidence, when looking at the arc, again, considering mother's young age and where she was by the time of trial, that she had come to a place of accepting the medication. And as Dr. Carbone said, Hospitalizations are part, yes, Your Honor?
Don't we have to, I mean, the judge here evaluates, of course, the credibility of the witnesses, right?
Yes, Your Honor.
And there's no question that there was improvement on the mother's part, commendably so, before trial. Where did the judge err or abuse discretion by saying that that wasn't a long enough period to feel comfortable with respect to the mother's ability to continue to parent? In other words, it was pretty evident that she did not have the proper diagnosis or follow through with her treatment until close to the trial time, close to the time of trial, right?
Well, there was an initial care and protection that was filed, and mother did receive the diagnosis and treatment and was able to complete service plan to the point where that care and protection was dismissed. So that was the earlier part of the matter. For the second care and protection, there absolutely were ups and downs in mother's compliance with her medication, and she acknowledged that. Mm-hmm. And the question is, and I submit to the court, based on everything that mother had done with her work, her otherwise capable parenting and lack of concerns other than housing, the fact that she found the wherewithal to leave an unsafe situation, and the testimony of the clinical experts that mother deserved one more chance at this. And there were ongoing, important, I would submit, live issues at the time of trial, where DCF was, during trial, had stated that it was seeking to put together a treatment team meeting. And mother had had a very difficult time accessing treatment with her therapist, who was unavailable often, not only for the mother, but for the department, found it difficult to communicate with this therapist. So these things were gelling at the time of trial. Mother also was working with DMH regarding housing. And again, that was a relatively recent issue. So I submit that based on her progress and the open items that were moving towards resolution, actually during the trial, as the work progressed, that termination was not necessary, that it was an abuse of discretion to find that mother would remain unfit into the future. Regarding housing, again, mother had housing. She was staying in a dormitory at the time of trial as a temporary measure, but was, again, working with the Department of Mental Health to access housing. And I would ask the court to also consider that this determination of harm to the child was really looking at potential future harm. That in Rona, this court said that evidence of unfitness based on a future harm requires even stronger evidence. And I submit that that evidence was lacking here. Regarding the evidentiary issues I raised in my brief, I would briefly say that with respect to the evidence from the father, the department says, well, you know, the burden was on the mother to subpoena the father. And I submit that based on the fact that the father said he was going to have nothing to do with the case, the trial judge found that he abandoned the proceedings and that the subpoena to him for the matter was returned unservable, that would have been a futile act to try to subpoena the father in this case on these facts. And that in the Luke matter from which that statement comes, that the person seeking to prohibit the testimony has to try to subpoena the party. In that case, Luke was talking about, court investigators who presumably are, reachable by service. And that's a very different situation than what we have here. In fact, in adoption of Renee, this court faced a similar issue and said in footnote 8, there's nothing in the record to indicate that the mother was foreclosed from subpoenaing the hearsay declarants to testify at trial. And again, I just submit there are very different facts here, and that the father, even though ostensibly a party, was did not receive service for the case and, as the trial judge found, abandoned the proceedings. Related to the other category of evidence, I would rest on my brief with respect to those evidentiary arguments.
Okay.
If there are no further questions from the panel, I would rest on my brief.
I'll inquire. Yeah, I see none here. And no further questions. Thank you for your argument.
Thank you.
Counsel for the child?
Excuse me. Good morning. May it please the court. My name is Alan Campbell, and it's my privilege to represent the subject child in this matter. I don't want to rehash the argument about mother's fitness, so unless there are specific questions about that from the panel seeking child's position, I'd like to turn to the visitation issue. And it's the child's position that the order was an abuse of discretion in that it contained a condition that child's right to see her mother 4 times a year would be null and void if mother missed 2 consecutive visits for any reasons. The judge had already found that visits were gentle, loving, and child-centered, that there was a strong bond, and that it was in the child's best interests to have continued contact with mother. To then break that bond, completely break the bond and do away with the bond, if mother missed 2 visits for any reason is simply unreasonable. Now, the conditions that a particular visit could be canceled if mother, or stopped if mother was unstable or acting inappropriately, that's fine. Child has no problem with that. But the blanket, there is not going to be an obligation ongoing if mother has missed 2 visits is simply unreasonable. And just logically speaking, the judge had set this up in their view of the case, that the issue before the judge was, do I believe that mother's going to continue to take her medications? Because it's largely uncontested that when mother took her medications, she was a good parent. So in terminating mother's rights, the judge found that mother wasn't going to continue to take her medications. To then set up an order and say, yes, it's in child's best interest to have visitation, and then under Ilona, the second prong, implicitly that an order is necessary to protect that bond, and then say, if mother misses any 2 visits, which is likely to happen when she doesn't take her medications, you're not going to have those visits anymore. It's just not consistently logical.
The order doesn't say the visits are terminated. It leaves it in the discretion of the adoptive parent.
It does, but again, the court had already implicitly found that the order was necessary to protect the bond.
Well, maybe or maybe not. Is
under
there
Ilona,
any evidence that the pre-adoptive parent would object to visits, which is normally when an order is entered, or in this case, perhaps because the pre-adoptive parent lives so far away?
I believe the record was silent as to the question of whether or not they would. And the reason I say that the judge implicitly found this is under Ilona, which presumably the judge followed. Before you enter an order for post-adoption visitation, you have to find 1, that it's in the child's best interest, and 2, that the order is necessary.
Right, but then with that condition, the judge, maybe expressly, I can't remember, found that per the usual presumption, the adoptive parent will act in the child's best interests. So even if there's no order in place because this condition has been violated, why can't we presume that the maternal grandmother will act in the child's best interests?
Well, and again, this is somewhat, and I hate to sound like a broken record, but to enter the order, the judge had to have found, implicitly had to have found that an order was necessary to protect the child's best interests. That's under Ilona. Those are the 2 prerequisites to entering an order for post-adoption visitation. So the judge had already found, even if it's implicitly, had already found that an order was necessary. To then strike it and I'm not arguing this from mother's point of view. I don't, not to be cruel, I don't care about mother. I care about my client and my client's best interests. Child wants to see mother. In fact, child wants to go home to mother. and the judge found that the ongoing contact is in the child's best interest, and I need to enter an order to protect that. But if mother, for whatever reason, misses 2 visits in a row, I'm going to punish the child by not requiring or not having an obligation to provide those visits. If the judge thought that and at this point there actually wasn't there was an idea of what it would be, but there hadn't been an approved pre-adoptive placement to this point. So for the judge to say that this person who I don't actually know who they're going to be and there's no evidence as to whether or not they'll provide visits, I'm going to leave it to their discretion, would in and of itself be an abuse of discretion. That was the thought, was that it was going to be grandmother, but the ICPC hadn't been approved yet, so he can't be relying on that. And there wasn't testimony, again, as to whether or not they would provide visits. And just in my very quickly, DCF argues that the condition was necessary to prevent disruption of a plan. I must be missing something, because the post-adoption visitation order wouldn't come into effect until the child had already been adopted, and I'm not certain how you can disrupt an adoption that's already final. And my time is up. I would love to talk more.
Time is up, and I see no additional questions. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Claire Gilchrist for the Department of Children and Families. We're asking you to affirm the orders of the lower court today, terminating mother's parental rights and placing reasonable limits on the post-termination and post-adoption visits. Here, there was ample evidence to support the court's conclusion that mother's cycle of mental health decompensation led to her being unreliable to provide safe care for the child. Her decompensation led to hospitalizations where she was physically unavailable, safety threats, as well as loss of housing. And furthermore, this was a pattern that had been ongoing at least for 4 years in Massachusetts, or almost 4 years in Massachusetts. This was the second care and protection. There was also a reunification attempt during this current care and protection that wasn't able to be followed through on because mother again stopped her medication and decompensated. So based on that lengthy pattern of behavior, the court was correct to terminate parental rights. Furthermore, mother's own very disruptive behavior to her child's permanency was another reason that that it was in child's best interest to terminate rights, because mother had disrupted a foster placement with kin earlier in the case, and then she had disrupted the pre-adoptive plan during trial. And therefore, there was a real concern here. If we're going to allow mother to come back in 6 months on reviews and redetermination, how severely disrupting that could be for a child, and had already been for her. In terms of the visitation order, just to respond to some of the points raised by my brother, there were severe consequences to the child of mother's disruptive behavior, as I just mentioned. And so the court here carefully crafted an order that would, that recognized this bond that was for the child to transition to a new home, but also protected her from this disruption to her permanency. And the order was not just for post-adoption visits, it also was post-termination, so it covered that period where the department still has custody and prior to adoption, and mother's behavior could absolutely disrupt permanency during that period.
So once the adoption either goes through or is about to go through, is the visitation order redone by the judge? At
the adoption proceeding, there is an opportunity for the judge to hear child, for example, on the order and
So if
issue a
it's-
final order.
If the adoptive parent is in fact the maternal grandmother who lives pretty far away, would the judge craft a new visitation order in that instance?
It's not that the judge automatically would, but child can be heard at the adoption proceeding on the order. Child can be heard any time in the trial court up until the finalization. They want to return to ask for a modification of the order. And just touching on the argument that mother had improved by the time of trial, and it was abuse of discretion for the court to find that her unfitness would continue indefinitely. Just to point that even during trial, when mother was stating she was medication compliant, she was not stable in her mental health. She had been requesting to have her old social worker back. When she got her back, she had this outburst and told her, you know, I don't want to work with you. She then, during trial, is when she disrupted the pre-adoptive placement. She also, during trial, testified she didn't know if she couldn't say definitively if she would continue taking her medication if she returned to North Dakota. So given that mother had these equivocations about medication for years, and that even at trial she couldn't definitively say that she would continue taking it, the judge did not abuse discretion in taking all of that evidence into account, and she made credibility determinations around mother's nurse practitioner, which she was entitled to make.
Did you want to address the issues raised by your brother about regarding the father, whether the court appropriately found he abandoned, whether there was any burden on the mother at the time of trial?
So, yes, I mean, the case law is clear. The burden is on the party challenging the statements to subpoena the party to court. There was an address in the case record for father, a last known address that as of 6 months before trial. So there has to be an effort there. And, you know, in our cases, there are a number of times where a parent may become unreachable or has decided not to participate, may be living in another state. And so, you know, are we going to say that every time that happens, no evidence of statements from that parent can come in? I mean, there has to be some showing of attempts to bring someone in. And even if your honors decided all those findings from father's statements were error, that doesn't affect the outcome here. The judge primarily relied on those statements in finding father unfit, and so there was overwhelming evidence from other sources of mother's unfitness, and even from her, you know, her own testimony and other witnesses. So it doesn't have an impact on the overall outcome. If there are no further questions, I'll rest on my brief.
I see none. Thank you very much. Thank you, all three of you, for your input in these cases. They're always very difficult, and we'll take a very special look at all the facts and take the case under advisement. Our third case this morning is Foreman versus Foreman, also partially impounded, 2024-0930.
May it please the court. Matthew Barak for the appellant, YULIKA FORMAN. The lower court committed error in 3 ways here. First, and most importantly, the lower court abused its discretion in applying a valuation date of April 2020 instead of at the actual time of the division of April 2023, when the lower court was empowered to adopt an equitable remedy under Austin. Second, by failing to explain how and why specific performance was a suitable and equitable remedy after the holdings by the lower court in the first trial. And third, by failing to actually apply an equitable remedy under the standard articulated in the footnote in Austin. Let me start by addressing the Austin footnote, as it touches upon all 3 concerns before this court. The Austin footnote specifically outlines that in a situation where a party has breached a prenuptial or antenuptial agreement, the probate court has equitable powers to adjust the distribution of marital assets. Here, the lower court found after the first trial that the party's antenuptial agreement was enforceable, but also, and critically, that the husband had substantially and materially breached the party's antenuptial agreement. And as a result, the lower court determined that she would apply an equitable remedy, quoting specifically from the footnote 7 in Austin after a second trial. And that brings me to the first error here. The lower court, in applying the valuation date of 2020, instead of at the time of trial, is error. It's error because of the following. One, the lower court seemed to struggle with her authority to determine this equitable remedy.
What do you mean by struggle with her
Well,
authority?
I think what the court did, and if this matter were to go back under a proper instruction related to the powers under the equitable remedies that are allowable under Austin, the court would have instruction to understand that in a court of equity, because the husband had materially and substantially breached the agreement, she had the power to choose a different date. What I mean by struggling is she said in the judgment that it was unfortunate that she couldn't use that later date. I think we can...
You're saying she didn't recognize...
I think
that
she did
had
not
the option.
recognize that Austin, when you start with Austin and the equitable powers, when she made that determination that he breached the agreement, that she did indeed have the power to go back and choose a different date. She was not bound by the 4 corners of the agreement. And when you read the judgment, she seems to indicate she was. And I think that's error in terms of her application in the first instance under Austin. And secondly, case law has now made clear, the Obara, I'm mispronouncing it, Kashani case, which is in our brief, that a judge has the power to determine a later date for division of assets when it's only due to passive gains, such as what was had here. So under any analysis of the hypothetical amount that was determined by the court, whether we use and credit the husband's expert or whether we use and credit the wife's expert, she still had the power to go to the second date because under Obara Kashani, it allows the court to utilize a later date when the asset is actually divided. And here, that would have been an equitable remedy.
So is there any evidence that you can point to in the record that would tell us what that 2-year difference would mean?
Yes, it's contained within our brief. I believe it is an additional $400,000 and change.
I saw it in your brief, but in the record.
In the record, I think we pulled it from the record from the testimony of both experts. And I'm not sure if it's in the findings per se, but it is, I believe, contained in the record because I wouldn't have been able to figure it otherwise. It was about 1.5-ish was what she determined and divided it by 2. But if she credits and goes back and credits the husband's expert testimony, it's approximately 1.9 and change. So it's about 250, about 1.9 million and change. It's an additional 400 and I think almost $440,000 divided by 2. It's approximately $215,000 to the wife. And if she had done that, I don't think we would be here because I think there would have been an argument that was equitable. Our issue is that this is a court of equity, and one of the maximums of the probate court is that wrongful conduct, the wrongdoer, should not be rewarded here.
Well, of course, the judge found that there was breaches of the agreement in terms of withdrawals from the contribution account, was what you have all referred to it, the Schwab account, by both sides.
One time.
Right.
But 8,000, my client.
And only a few
hundreds of thousands of dollars, the husband.
Yeah.
I think her one breach of 7,800 is
Do you
is
contest
immaterial.
that some of the husband's withdrawals benefited your client?
I think the only withdrawal to the extent that it benefited my client would have been to the purchase of the marital home.
For
Because-
$1.7
because
million.
the down payment of which they split.
There were some withdrawals for renovations and purchase of your client's car. Is that not correct?
I think you're correct.
Okay.
But again, I think that it kind of, it's sort of almost circular in the sense that this account and this agreement was supposed to be segregated. It was not supposed to be an operational account. And my concern here is when we read the judgment, when she puts specific performance as the ultimate remedy rather than an equitable remedy here, she doesn't explain how and why. So
Because
to
it
your
makes
point,
she's trying to make your client whole for the breaches. So going back to the valuation date, I take your argument to be that had the husband not breached the agreement, your client would have received the property sooner? Is that your argument?
that's what the judge
Okay,
indicated,
so-
and yes, I think she would have received
And
it
so the
sooner.
judge said it's unfortunate litigation delayed her receipt,
Correct.
but the litigation was not limited to determining a remedy for the breach, right? I mean, the trial would have happened regardless because there were a number of issues that were being litigated.
That is true.
So how is it that the breach is what caused the delay of your client's receipt of the property?
I think that if not for the breach of the agreement, once the agreement was enforced, there never would have been a need for a second trial, and she would have had
No,
access
but
to that
You
money.
just said it was true that there was a need for the second trial because there were other issues being litigated. And until the judgment enters, she's not going to get any of the property.
Yes and no, because I think that if the agreement itself had been enforced, if he had followed the agreement and didn't breach the agreement, and the agreement was accepted by the probate court, there's an argument here that she may not have needed to seek to not enforce the antenuptial agreement.
She would not?
It's certainly possible. If the account had grown,
There was actually even a third trial here related to child.
yes,
so-
that is true, but if the account had grown as it could have, and there wasn't a bifurcated, and then, you're right, a trifurcated decision here, if it wasn't for the breach, the amount of money would have been available in the account. I believe there's $900,000 and change in the account when there was supposed to be a minimum of, double that at the time. I mean, he took out over $600,000 from the account. He never maintained the account. So I think I guess what I'm
Isn't
saying.
that kind of a red herring? Because both experts gave evaluations as to what the account would be worth had the withdrawals not been made and had the $6,000 monthly contribution been made throughout. In fact, the experts didn't differ tremendously on the amounts, maybe $500,000 or so, if I'm not mistaken.
Well, no, I think it's double that. One was 3.8, and the other one was 1.5. It's a tremendous disparity in terms of the experts. And again, I think, although she certainly has the discretion to adopt the husband's expert opinion, I think she still needs to inform and she needs to justify and explain why specific performance is indeed an equitable remedy here. She does not. She just calls it fair and reasonable without articulating any facts, without articulating any standard. And I think, to me.
Why is that so necessary here? Is it so difficult to infer what her analysis is here?
Well, I think it doesn't flow rationally the findings don't flow rationally to the judgment. And here's why. I can't tell you why she picked this. When I read this judgment, when I read it time and time again, I don't understand why she says after the first trial, we're going to have a second trial and I'm going to apply an equitable remedy under Austin. Then she starts the second judgment, the judgment in question here, by describing that she's going to pick an equitable remedy under Austin. And then she goes through the analysis with my concern over the date. She goes through the expert, and then she just concludes that the minimal amount of the $820,000 is what the wife would receive. So to me, there's no.
Why wouldn't one infer that that's what the judge thought at that point?
Well, I think that's what she concluded. But my issue is under the Austin standard. Her judgment here is saying that there needs to be an equitable remedy applied. The husband clearly breached the agreement. That's undisputed. On a court of equity, he should not be allowed to get away with breaching the agreement to his benefit.
And he
It's as if nothing happened.
He wasn't. The judge crafted an equitable remedy in the nature of something akin to restitution.
No, she did not. I disagree with that.
How is that wrong?
Well, I'll tell you what. First, she picked the minimal amount with $820. There was no need to litigate this.
That's because the amount that she determined in what would be akin to restitution was less than that amount.
But we don't know how that's equitable. She didn't look at the 20834 factors. She didn't address whether it's fair and reasonable. She concluded it, but she didn't ever explain in her judgment how and why that was an appropriate, fair, and reasonable determination.
So you want it sent back and have an explanation, and what if the explanation simply supports exactly what happened?
Well, first I want it sent back because I want the judge to be empowered under Austin, which I believe she already is, and under the applicable case law to determine a different date than was in the agreement.
He or she would also be able to choose the other date.
Yes.
So so what we're asking for is, are you sure you understand you have the authority to do this? Yes, I now understand I have the authority to do it. I'm still picking this date, and you're in the same place that you were before.
That could be,
Okay.
but when I read this judgment, I think I have the firm conviction that comes away from it is if she had known.
You think you can convince otherwise? Okay.
Yes, I think that if it goes back otherwise, I think if it goes back, she's going to pick the later date. And if she doesn't, I want an explanation as to how.
I do review the fact that she was quite clear that I think she used the term actually walking away, if I'm not mistaken. Your client with, close to $3 million was equitable.
Well, she didn't say that. I think she kind of.
That's how I read it.
Yeah, but that's 12% of the marital estate.
That too.
Yeah, out of 100%. I mean, so he's walking away with more, and we're not asking for a division more so.
Oh, nor could you.
No.
Given
no.
also the disparity of the resources when the two were married.
Exactly, and I think the struggle here is with the fact that she didn't explain how and why, and she seems to, I think, have misapplied the case law and her powers under Austin.
I'm hearing a little bit from your argument that you want a second bite of the apple. You want to go back and argue the same points again. Am I right?
No, I disagree with that. I want her to I think that the judge would have selected a different date if she had understood that she had the power to do so. And that's really the first and foremost request, combined with a request that she explains how and why it's equitable. And then the other thing, I know I'm going to run out of time, but in regards to specific performance, I mean, the Austin footnote doesn't give great guidance here, but when the court has been confronted with an area of specific performance, as in the Dominic case, which was an oral contract, I think by analogy it's somewhat applicable here, because what the court said there, I think, were two key holdings that I think should apply in areas where the Austin footnote may be applied to a matter, and that is that the judge must make a finding that it is fair and reasonable when there's specific performance, and also that the court said in making that determination of fairness and reasonableness, the judge should consider at least the following. And one of the 8 factors that Dominic highlights that I think this court, when it goes back, should, is the mandatory and if a judge deems appropriate discretionary factors set out in 2834. And I think that should be the standard that should be applied if and when it goes back to making an equitable remedy. I'm out of time. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. I'm Susan Stenger. I'm representing appellee Samuel Foreman, and with me today is Julia Payton, who was on the trial team for Mr. Foreman. I'll respond first to a couple things that Attorney Brock said. As to the valuation date, the judge determined that specific performance was the appropriate remedy, and in fact, that's what the parties contracted for as the appropriate remedy in the event of a breach. Once she made that determination, she was obligated to follow the contract. The contract specified a valuation date, which was 3 years after, which was in 2020, which was 3 years before the date that Ms. Foreman is now asking
Is
for.
the appropriate one, yeah.
Now, Justice Shin, you're correct that no money would be paid out in this case until a final divorce judgment entered.
But for the husband's breach, the case would have ended far sooner, and so the litigation was much delayed because of the breach. Why wouldn't the judge have the power to choose a different date?
I also want to, this case was also going on during COVID. You know, the length of the litigation was not solely attributable to the husband. And there was also a GAL appointed in the case on children issues, so there was a lot going on that was taking the time. But the judge considered all that when she decided that her remedy would be specific performance. So that had to be part of her part of her analysis as to what was the appropriate remedy.
But she said she's without discretion to deviate from the valuation date. That, to me, suggests something else.
Well, but once she determined that the contract was valid and enforceable, and then she determined that specific performance was the proper remedy, she has to follow the terms of the contract. It's a question of law. And I think she also, in making that decision, factored in a lot of other equitable aspects of this case, and including that Ms. Foreman received a lot of things that she wasn't entitled to under the contract. Mr. Foreman was to pay her student loans when they got married. The amount listed in the agreement, she listed $25,000. In fact, they were $10,000 to $35,000 more than that. He paid them all off. Although the contract said if they bought a marital home, it would be in joint names, it said nothing about value. They bought a very expensive home, $1.7 million. Mr. Foreman later put in $2 million of renovations into that house. So when the divorce came, the equity in that property was divided 50-50, and she got $2 million out of that house that there were no numbers in the anti-nuptial agreement about that. She also, by agreement, he gave her all the furnishings in the house, and very significantly, the contract obligated her to move out and the house would be sold upon judgment. But he agreed to let her live there an additional 3 years until their youngest child was out of high school for rent-free, and he has been paying all of the insurance and all of the real estate taxes. So the judge took all of these things into consideration in fashioning her judgment and in deciding that the enforcement of the contract and its terms, including evaluation date, were the proper remedy.
But you believe Austin gave her the discretion to deviate from that termination data specified in the contract?
Your Honor, I think Austin gives judges wide discretion in fashioning a remedy, so I would say yes before she determined that specific performance was the appropriate remedy in this particular case. And specific performance means you enforce the terms of the contract, including the valuation date.
That's because the contract itself says that the remedy should be specific purpose.
Yes,
right?
and Ms. Foreman agreed to that.
Otherwise, the judge would have broad discretion to choose the valuation date she thinks to be most
I believe
equitable.
that's correct.
Okay.
I would also like to go to the relief that Ms. Foreman's asking for, which is a complete equitable division of assets under Section 34. There's no authority for that. All the law, DiMatteo and other cases are,
She says she's not asking for that.
she says that?
In response to one of my questions, I
Oh.
asked exactly what you're asking for, and the question only was limited to going back and changing the valuation date. But in the brief,
Okay.
there's more, but that's what we
Forgive
heard
me,
today.
I didn't hear that. You know, and I will say in the brief, over and over again, and without authority, Ms. Foreman argues for a complete equitable distribution under the Section 34 factors, and the valuation date is a small argument at the end of the brief. So I would like to talk also about the expert valuations. Mr. Resnick, the expert for Mr. Foreman, his calculation completely neutralized the breaches. There was no harm to her in the long run. She got all the money that she bargained for. And let's see. His calculation is not speculative because he used the exact method that husband had been using, in which the judge found specifically the husband was entitled to use in managing the investments of the Schwab account. And importantly, husband always limited the portion of that money that went in the stock market to 17%. The wife's expert, in his analysis, put 100% of the money into the S&P 500. And that put 100% of the risk of those investments on the husband because the wife had her guaranteed minimum. Ms. Foreman's expert, Mr. Liriano, testified that he never even looked at the antenuptial agreement till the day before he testified. So he did not know that that account was to be split 50-50 and that the husband would bear that risk. He thought it was all for the wife and that why not go crazy with the investments and see how big we can make them with aggressive investing because she had the guaranteed minimum. The judge found Mr. Liriano's analysis unhelpful. If your honors have no other questions, I'll rest on my brief.
I see none. Thank you both very much.
Thank you.
And we're going to hear one more case before we take our afternoon, or our morning break, excuse me. Massachusetts Department of Transportation versus United Steelworkers, Local 5696, case number 2025-0123.
Good morning, and may it please the court. My name is Alfred Gordon O'Connell, and with me is my partner Jillian Bertrand, and together we represent proudly the United Steelworkers Local 5696 and the hardworking employees of the Massachusetts Department of Transportation who work every day to make sure that we can get where we're going. As you know from reading the papers, this case stems from an arbitrator's finding that Mass DOT failed to even consider possible accommodations to the grievance, sincerely held religious belief regarding the COVID vaccine. I am grateful that this is the very last COVID case in my filing cabinet, and I hope it is also for you. But a breath of fresh air in this case is that all parties to this case agree that Mr. Baraka, who is watching today virtually, is not someone who found religion to evade the vaccine, but someone who actually had a sincerely held religious belief, which is why the department reinstated him as soon as conditions allowed. The through line in this case, therefore, is really about two things. It's about what the arbitrator found, and almost more importantly, what he didn't find, and what the arbitrator ordered, because neither what he found nor what he ordered exceeded his authority. I'm going to read to you a sentence from his decision, which encapsulates what the case is about and which shows how the department and the Superior Court went afield in this case. The arbitrator wrote, "It may well be that finding accommodations for the grievant would be difficult or might not have been possible. However, the DOT had a responsibility to consider possible accommodations and make a determination whether an accommodation was possible based on the gathering of substantive information." That should be the flag that starts this case, because the Superior Court determined that the arbitrator somehow substituted his judgment about what accommodations might be possible, when in fact the arbitrator found that accommodations might not be possible at all, but under the contract, under the anti-discrimination provisions of the contract, the department at least had to look and gather substantive information and try, and he discredited the Commonwealth or the department's testimony that they did indeed try. There are two legal constructs that the court should be guided by. One is the construct of non-delegable management rights. Those are things that would block negotiation, would also block arbitration. The other construct, which is sort of woven throughout the department's brief, is the contract of a public policy, whether an arbitration award violates public policy. But those are separate legal avenues, and I'll take them each in turn. The first being, and the one that the Superior Court rested on, was whether there was a non-delegable management right. The union takes issue at the start that there was here a non-delegable management right, because as the Supreme Judicial Court has instructed, first of all, those are typically found in the enabling statute itself. And the only words in the enabling statute that the court relied on were the words economy and efficiency. And yet the court determined that the right here was command and control functions during a pandemic, which is not quite listed in the enabling statute.
What about the more general role of DOT, though? I think the judge quoted ensuring our safety on the highway or involved in big highway projects. I mean, that's public safety of sorts, isn't it?
Of sorts, Your Honor. The court decisions regarding to public safety all relate to police officers and firefighters. So let's not conflate the two concepts. But there certainly is a safety element on the roadway. The hardworking people of Mass DOT, our highway maintenance workers, are on those roads every day, making them safe for us and putting themselves in harm's way in order to make sure that the public is not. But if you move, even if you accept somehow that that underlying public safe passage element is imbued as a non-delegable management right, then you have to move to the next step.
Well, I'm not ready to accept that.
I'm with you, Your Honor.
You said usually the right is that it's typically found in the enabling statute. Where is it non-typically found? Isn't it always found in the statute?
Well, so the court in the Board of Higher Education case the Supreme Judicial Court opined that even if the enabling statute is not clear, you can draw general public policies out of an enabling statute. You have to look closely, but when the statute is very general, such as this one, the court said that those statutes must yield to the obligation to engage in collective bargaining unless the public policy drawn from the statute is so comparably heavy that collective bargaining must be denied effect. So I accept, the union accepts that the words economy, efficiency, and the entire construct of the roadways does heighten, perhaps, a safety element. But then, since the statute is so general, the question is, does it yield to collective bargaining or arbitration, and is the public policy so comparably heavy that it must?
How can it not be heavy? I mean, DOT takes care of the roadways. We're in the winter right now. They're out there all the time, sanding, salting, doing things. Isn't that for safety purposes?
Certainly. The question then becomes how the department and the Superior Court defined the non-delegable right at issue. And this is the way the court defined it. It is that the court stated, staffing decisions taken in furtherance of efficient and effective operation of the command and control functions of the Highway Operations Center, particularly during the COVID pandemic, are non-delegable powers reserved to Mass DOT. That is horribly narrow. By the way, opening words, staffing decisions, really, I think, is the counterpoint in this case. Because when you look at, let's just presume for the moment that this is a non-delegable public safety obligation that Mass DOT has. Then the questions become, does the arbitration decision in any way encroach on that public safety right? The first part of that analysis would be, is the ability to bargain completely removed in an area? The collective bargaining provisions at issue in this case are the just cause provisions and the non-discrimination provisions of the contract. Even the department doesn't suggest that the non-discrimination provisions of the contract are non-negotiable because of some public safety right. The department can't say, oh, public safety, therefore we're going to discriminate against you based on your race or gender or sexual orientation. So when you turn the page and move beyond that, the question is whether the arbitrator has done something in his decision that encroaches on that right. And he could do that in one of two ways. His findings could be at odds with the department's considerations. Here they are not, because unlike the department and unlike the Superior Court, their determinations that the arbitrator encroached are incorrect because the arbitrator did not find that there was any particular accommodation that would be required here. All the arbitrator found was that the department did not give consideration to any accommodations in a meaningful way. He left open the possibility that if the department had looked at whether the employee could work from home, or looked at, importantly, whether there were any other jobs he could have transferred into, the arbitrator found that they did not meaningfully look at whether any other jobs existed. Mr. Braca has an MBA. He could have been an analyst. He could have been any other number of things other than doing the great work he does at the Highway Operations Center, but the department never bothered to look. So even looking at the arbitrator's findings, they do not encroach because he did not find that there was an accommodation. But more importantly, the case law does not focus on the opinion of the arbitrator, it focuses on the award of the arbitrator. And the arbitrator here awarded back pay and seniority benefits to a man who had already been reinstated to his job. How could the award of back pay or benefits possibly encroach on the department's non-delegable rights? It is akin to all of the teacher discipline cases that you've seen, and a number that you all have heard in your time on the bench, where the teacher statutes give public schools and boards of higher education the unfettered right to appoint teachers. But parties can agree on certain provisions and criteria that need to be considered. And an arbitrator, although he, she, or they cannot promote a teacher or reinstate a teacher, can give some kind of remedy for a breach of the criteria or promotion criteria or procedures. And that is literally all that happened here. The arbitrator said, Mr. Braca has already been reinstated. The department never actually gave him the consideration he was owed. So in order to compensate for that, I'm merely going to order that he be given 1 year of back pay, between the time that he was fired or put out on unpaid status and the time that he was reinstated. And so that's really the nub of the case. Did the arbitrator's order in any way interfere with the Commonwealth or the department and its non-delegable rights? It certainly doesn't compel the department to do anything. It doesn't compel the department to accommodate him. He was already reemployed.
It compels him to pay a year's worth of salary.
Yes, but all of the cases in the teacher cases where the courts were constrained to reinstate or promote or whatever the action was that the union was complaining of, the Supreme Judicial Court has specifically allowed back pay.
That's not this case. Your client was reinstated by virtue of his capability and because he went back on his own. So the arbitrator, as you pointed out, did not award that. Did specifically award back pay, not in the same, in other words, had the arbitrator said, be reinstated and get back pay, that would be different.
Yes, Your Honor.
Okay.
And when you read that analogously to the teacher cases, even if the arbitrator would have gone too far by requiring an accommodation or by requiring reinstatement, again, the union does not believe that that would violate the enabling statute, but putting that aside, if all the arbitrator did was say to the department, you failed in the procedures and criteria required under the non-discrimination provisions to look at reasonable accommodations, and therefore I'm going to compensate the employee for that failure, even though the arbitrator didn't have to take the next step. It is the same construct that you would see if you move to the other legal analysis, whether this award violates public policy. All of the public policy cases have the same vein. The question there is
Well,
not.
it could have violated public policy, because if we were to find that, in fact, DOT does have the right to say, within the enabling statute, when we're being efficient and we're taking care of what we need to do in terms of road safety, we need to make our own decisions as to who can work where and how, period. And so that would then, of course, go against the cases that you're relying upon, correct?
I don't believe that they would, Your Honor, because the case is there. I think a cogent example would be a police officer transfer case. A case where a police officer believes he was improperly transferred or should not have been transferred or was transferred for a discriminatory reason. An arbitrator would have the power, certainly, to issue some kind of monetary award, for example, for the changes in shift differential or whatever might have happened as a result of the transfer, but would not, in violation of the commissioner's statute, the police commissioner's statute, have the power to transfer. It comes down to what the order of the arbitrator is, and here it's merely an order of back pay. And then when you take the step back to Chapter 150C and the construct that's applied, this court is cautioned not to re-argue or rehear the factual findings of the arbitrator or even the legal conclusions, even if those legal conclusions are erroneous. The question is, did the arbitrator order the department to do something that violates the law? Did the arbitrator order the department to do something that interferes with a right or that violates public policy? And what did the arbitrator order here? Payment of back pay to a sincerely religious man who did not get the care and treatment required because the department did not even consider whether there might have been an accommodation.
But as you've acknowledged, it's more than back pay, and I think we'll hear from your brother that the award was tantamount to reinstatement.
Except it's not tantamount to reinstatement, Your Honor, because the grievant was already reinstated. He was already employed. If the arbitrator had ordered him instated, that would certainly be a different matter. And again, if you get back to the police discipline cases, I know that a number of you have heard these kinds of cases. The question isn't, in those cases, whether the order of reinstatement itself somehow, or whether the activities that led the police officer to be discharged somehow violate public policy. So not the underlying question or the underlying matter. The question is, does the award in any way violate public policy? And here, it is just the payment of back pay and seniority. And again, it's to compensate for the fact that there was a period of time when Mr. Braca was not even given the consideration that the sincerely held religious beliefs that both sides agree he held, he was required under the contract, which reflects in some ways the law, that he have some proper consideration. And the arbitrator found Mass DOT just did give short attention, did not consider other possible alternatives, did not consider whether he could have worked from home. But the arbitrator stopped short of saying that those accommodations were appropriate. He even said, as I quoted to you at the outset of this argument, that it might very well have been that it would not be possible. Had Mass DOT done its duty and made those considerations to avoid discriminating against Mr. Braca based on religion, we would not have won this case. We would have lost this case, we would not be here. But now that an arbitrator has issued an order, this court is bound by his factual findings and legal conclusions and should only be disturbing that order if what he actually ordered the department to do somehow interferes with their rights. It's impossible to do so. The COVID pandemic is over. The non-delegable right that they purported to have doesn't really matter anymore. Mr. Braca has been working for the last 3 years without incident. There's really nothing that the arbitrator did that interferes with that. So we are hopeful that this court will recognize its narrow considerations and allow the payment of back pay as the arbitrator had ordered.
Thank you.
Thank you very much. Appreciate it.
So one final, the CBA contains an emergency clause in section 2.1, I think it is, but exempt to just cause and non-discrimination. The clause is DOT can take all necessary actions to carry out its mission in emergencies. Is that rendered superfluous by their position today? Does that only make sense if it was a non-delegable right?
Not really, Your Honor. The opening line of Section 2.1 says, except as otherwise provided for in this agreement. And so that right to engage in emergency procedures does not allow the department to fire people whenever they want. They have to have just cause. It does not allow the department to discriminate against someone. They must have a reasonable cause to make the rules. Consider headscarf cases or facial hair cases in the religious construct. If the department created a policy around those, would they hold up to scrutiny for efficiency and effectiveness? It's really the same thing here, but again, the award itself doesn't interfere in any way.
Good.
Thank you.
Members of the panel, may it please the court. Preston Bruno, Assistant Attorney General, on behalf of the appellee, the Massachusetts Department of Transportation. This court should affirm the Superior Court's vacatur of the arbitration award in this matter because it intrudes on the department's non-delegable managerial authority. Namely, in the context of awarding back pay, seniority rights, and benefits retroactive to the date of the grievance termination, the arbitrator intruded upon the department's non-delegable managerial authority to maintain a safe workplace and to provide critical safety services to the public in the context of making staffing decisions in the specific context of a surge in the COVID-19 pandemic.
But the decision was related to a procedural safeguard, really. Was there reasonable accommodation made?
Yes, Your Honor. The consideration was...
Or not even that. Did they essentially make an effort to make a reasonable accommodation? Did it make any showing that they thought about that and that they did that?
So, Your Honor, I think that contention overreads the arbitrator's award slightly. The arbitrator certainly found that the department did not do enough to consider whether or not the grievant should have been provided a reasonable accommodation. But nowhere in the award does he say that the department did nothing. He characterizes our approach as conclusory, but he does describe certain facts that we did engage in that suggests that there was some sort of investigation done here. For instance, Mr. Foti, who is the grievance supervisor, he testified before the arbitrator and indicated that at the time that the department was considering a reasonable accommodation, he was called and asked about the feasibility of engaging in remote work. Ultimately, it appears the arbitrator didn't credit Mr. Foti's testimony, but the arbitrator does not indicate that that call did not occur. Likewise, there's testimony that Mr. Mann met with the grievant, as well as Mr. Tynes considering the grievance appeal and engaging in some activities to consider whether a reasonable accommodation is appropriate. So ultimately, certainly the arbitrator did not credit our efforts in total.
I may have overstated that point. I think more of the issue is that what we're here about is whether the inquiry into reasonable efforts to accommodate.
So,
and if so, how does that intrude upon DOTs?
So that was the question posed to the arbitrator, and subsumed in the question of whether or not he was provided a reasonable accommodation is the question of whether his ultimate suspension and termination, which occurred before the arbitrator's award, was appropriate. Because if we didn't provide him a reasonable accommodation, the arbitrator would then find that there was no just cause to terminate him. And in fact, that was the union's position before the arbitrator himself. When the arbitrator describes what the union argued, I believe in the first sentence, he says the union argues that the department violated the just cause provision of the collective bargaining agreement. So this case, although the issue posed was about reasonable accommodation, also implicates just cause, termination, and therefore the ability to staff in a particular manner the Highway Operations Center. When we assess these types of grants of non-delegable authority, we're really asking in a general case like this, one, it's done on a case-by-case basis, which is important. That is to say, there are many cases in this area, but that they don't necessarily control on the facts of this case, which concerned the specific context of safety during a surge in the COVID-19
What is the
pandemic.
source of the non-delegable duty?
The source of our non-delegable duty is our enabling statute here. And
Just the words of the statute.
So specifically, the statute, Your Honor, reads, and this is Chapter 9C, Section 3, subsection 6 and 44. And beginning, it says, the department shall have all powers necessary or convenient to carry out and effectuate its purposes, including, without limiting the generality of the foregoing, the power to, and then it goes on. And if we look to subsection 6, it says, direct, coordinate, and supervise the administration of the department to promote economy and efficiency and to leverage federal funding power in private sector investment. And then if we look to subsection 44, it says to take any action necessary or convenient to the exercise of the power or the discharge of any duty provided
And
for
I
by
think
the
I've seen similar language like that in many enabling statutes for other agencies. So if those words alone would create a non-delegable duty, I mean, it would extend very broadly.
Yes, Your Honor, I think that I understand the concern about creating too broad of a non-delegable duty here, and I think there are two responses there. One is that because these are case-by-case analyses, we don't just say that's a statute and that there's non-delegable.
Well, that's what I was asking. The source can't be just the words of the statute. So how far beyond the words of the statute can we go?
So, Your Honor, in these types of cases beyond the statute, I should have said this, I apologize, when we're identifying the specific right at issue, we look to subjects that are reserved to the sole discretion of the employer by looking to statute, which we just talked about, tradition, and common sense. Mm-hmm. So I think statute comes in here, but also common sense comes in here as well. We're dealing with a staffing determination during an unprecedented pandemic. And I think common sense under those situations dictates that the department needs to have the ability to control who works in the Highway Operations Center, which specifically coordinates with emergency personnel in the cases of emergencies on the highway. Additionally, I would note that this sort of test is aimed at promoting both the power in reserving the power of the agency and also promoting political accountability. And additionally, public policy is a core concern when we're assessing non-delegability. Namely, the court has said that we ask whether the question of public policy and issue is so comparatively heavy that collective bargaining is to be denied effect as a matter of law. And then finally on this point, protection of non-delegable rights in the public safety context is particularly important because the court has said that public safety cannot be placed on the negotiating table. So here in the fall of 2021, during a surge of the COVID-19 pandemic, the department had to maintain the health and safety of its employees to ensure that it could provide services to the traveling public in the Commonwealth. The grievance role in the Highway Operations Center inherently concerned issues of public safety. As I just mentioned, they coordinate with emergency services, and I think the arbitrator explicitly said that this is, there were considerations of public safety at play in the Highway Operations Center. It's a safety-centered role, I believe, is the language he may have used. So the determination, or the department did not question the grievance, the sincerity of the grievance religious beliefs, as my brother noted. Instead, we explained that we could not reasonably accommodate the grievance by taking measures such as working in another space, working remotely, or working in another position. And the arbitrator disagreed with us on that score. And in the context of this case, we're not asking the court to find different facts here. The argument is that those specific findings are the findings that are reserved for the department. The department needs to be able to make the determination as to whether it can accommodate an individual, and accordingly, we're not specifically challenging the factual findings of the arbitrator here.
What recourse would he have? I mean, the Executive Order 595 has explicit language on reasonable accommodation. So if it's just up to the department, whether or not they made a diligent effort to determine whether they could reasonably accommodate him, what recourse does he have?
I think under the facts of this case, Your Honor, he would have no recourse. He would, I mean, he has been reinstated, and that was voluntary between the parties, but he would have no recourse. If we explicitly discriminated against the grievant in a way that was based on personal animus, a constitutional violation based on discrimination, or a statutory law based on
religious beliefs.
He would have no recourse, even if the department didn't consider a request for an accommodation at all.
I should say, I think I think in that circumstance, he may have recourse, Your Honor, under the discrimination exception to the non-delegability doctrine, if there was absolutely no consideration.
Well, what's the difference between no consideration and inadequate consideration, which is all that the arbitrator found?
I think there is a large difference there, Your Honor. Attempting to accommodate the grievance, or at least attempting to look into it, I think is a far cry from, sitting down and just checking the no box. The department did take efforts to assess the appropriateness of an accommodation. The arbitrator just found those efforts lacking. I think there is a gap there, a meaningful gap between doing something that's inadequate and doing nothing at all.
How does it intrude on some non-delegable duty to require the department to give adequate consideration to an accommodation request based on a sincerely held religious belief?
It intrudes on the department's authority, specifically in the context of this case, because it asks the department to take a different action in the context of an unprecedented modern pandemic, where it's attempting to ensure that there's public safety and ensure that it can provide safe roadways for the public, specifically in the context of the grievance position, which is focused on public safety. It's all of those facts together that makes this case, or that reserves this power as being non-delegable, and that differentiates this case from many of the other cases that this court and the SJC have decided. Looking more to the statute, again, the words economy and efficiency, as I just noted, must be read within the context of the grievance role, and his role is within the Highway Operations Center, and it's focused specifically on public safety. Additionally, I think the Boston firefighters case from the SJC from 2023, which we cite in our brief, is also instructive here on the relationship between non-delegation and the unique circumstances of the COVID-19 pandemic. In that case, which was a reversal of a grant of a preliminary injunction, the Supreme Judicial Court upheld the mayor of Boston's non-delegable ability to remove a testing alternative to a vaccine mandate. In doing so, the court explicitly said, given the unique circumstances of the COVID-19 pandemic and its threat to the health and safety of the public, the decision to remove the testing alternatives in defendant's COVID-19 policy constituted a non-delegable policy decision that could not be the subject of decision bargaining because any such requirement would have impinged directly on the defendant's ability to provide essential public safety services to city residents. And that's at page 564 of that case. I think that underscores the importance in this specific context of COVID-19. There was also a surge in that case, that non-delegability is at its height in terms of reservation of rights because of the concerns of public safety and because of the unique nature that the pandemic posed as a threat to public safety. My brother indicated that the department is not a public safety organization like a firefighter or police department, and as such, issues of public safety aren't necessarily important considerations. Notably, the Highway Operations Center specifically concerns itself with public safety, and were that not enough, we can look back to our enabling statute, this time to subsection 13, which specifically empowers the department to police, administer, control, and operate the highway system. I don't think there's any way to read the language police the state highway system that does not include some element of public safety. Additionally, my brother argued that there was, that we have muddled the public policy analysis and have not addressed the three-part test that they cite in the reply brief. And I would just note that decisions from both this court, specifically in the seminal City of Lynn decision, which established or at least clarified the three-part non-delegability framework, and the SJC's decision in the Board of Higher Education case from 2019 and the Boston firefighters case I just mentioned, all highlight the importance that public policy plays in assessing whether non-delegability is appropriate or not. Additionally, the union contends that there's been a procedural violation, specifically a violation of the anti-discrimination provision on the collective bargaining agreement. That is not what the arbitrator found. The arbitrator does not even reference the anti-discrimination provision in the arbitration decision. Instead, the arbitrator refers to the reasonable accommodation provision from the vaccination policy, which is not a part of the collective bargaining agreement. It's a completely separate policy. Additionally, there is some consideration due to the union's contention before the arbitrator that the just cause provision of collective bargaining agreement was violated, but there doesn't appear to be a contention that there were any procedures related to the just cause provision that were violated. And even if the anti-discrimination provision was violated in this case, it would not provide for, or would not get around non-delegability. And that's specifically because where you have a general anti-discrimination provision, that is a statement of policy rather than binding an organization to a specific practice. And that's the Middlesex County case we cite from 2005. Unless the court has any further questions, I see my time is coming to an end, and I will rest on my brief. Thank you.
No further questions. Thank you both for your arguments. We'll take the case under advisement. The court will stand in recess for about 15 minutes.
All rise.
Can you hear it now? All right.
right, well, we're almost at good afternoon, but not quite. So we have two cases that are left, and they're related, and both of you represent the same parties in both cases, but we're going to argue them separately, even just stay where you are, because the issues, of course, are different, and we think that makes the most sense. So the first one is Commonwealth versus Ally Jerome Mallory. Mallory is how you pronounce the name? Mallory? Okay.
Yes, Your Honor.
2020-1133. And so we'll start with that one.
May it please the court, Matt Spurlock for Ala Mallory. The Guardado-Bruin remand issues here on counts 3 and 5 and the enhancements 4 and 6 are very straightforward in light of the SJC's decision in Ferrara. So unless the panel has any questions on those, I'd like to jump right into the ACCA sufficiency issues that are presented in this appeal.
I do have some questions, not on the substance, but if we agree with you on that issue, Guardado, do we need to address whether the erroneous instructions on the ACCA charges were harmless beyond a reasonable doubt?
Perhaps not the instructions because everything is going to go back anyways on the remand, but
on the sufficiency, you say we would have to
yes,
address?
You would have to.
And then would we have to address the sufficiency as to all 3 of the predicate offenses?
Yes, I do have sufficiency challenges to all 3 of the predicates.
Okay, and we would have to address all 3 to determine which of the offense predicates he could be retried on.
I don't believe he can be retried on any of them because the Commonwealth did not have evidence.
I understand. I'm just trying to determine what it is we need to decide. So your positions, we would need to decide the sufficiency as to all 3 predicates.
Yes, Your Honor.
Okay.
You know, it may be helpful to the court if it does go to remand to have some guidance, but it's quite clear now after Ashford that reckless predicate does not qualify as violent assault and battery under the ACCA. So moving to the sufficiency questions, at the 2019 ACCA trial, the Commonwealth presented insufficient evidence to the ACCA jury to conclude that the predicate convictions were for violent crimes within the meaning of the ACCA under the modified categorical approach. And I'll start with the first predicate conviction, that's a 1998 conviction for an assault and battery with a dangerous weapon. That conviction was pursuant to a plea. Now, to meet its burden at the 2019 ACCA trial, the Commonwealth presented testimony from a victim witness. This case is really on all fours with this court's decision in Commonwealth v. Paris. And there, as Justice Englander explained, the testimony of a victim witness did not address what happened at the plea hearing or what the defendant agreed that he did. For that reason in Paris, and for that reason here, the evidence of the prior conviction by a plea was necessarily insufficient to meet the Commonwealth's burden.
So I read Perez a little bit differently. It seemed like that's where the panel was going. And then I read it as saying, well, but we don't really have to decide, because even were we to consider the testimony at the ACCA trial, that testimony itself did not establish whether the assault and battery was harmful or reckless. Do you read Perez differently?
I think it says both, Your Honor. I think it essentially, for both reasons, the evidence was insufficient. Even if I take the court in Paris to say, even if it's an alternate holding, even if they had considered that. But of course, the fundamental proposition here is that that is not probative, right? What a victim witness says, happened at the incident is not probative of what a defendant pled to in 1998. But I do agree that, Justice Englander goes on to say, even if we did take that victim witness testimony in Perez, it wouldn't really say whether it was a reckless form of assault and battery with a dangerous weapon or a violent form. That's true here also. But the more fundamental problem in both cases is that it's simply not probative of what was pled to.
It's true with respect to the 1998 ABDW. The 2007 A and B is a little bit trickier, I think.
Yeah, sure, I can get to that in a second. Are there any more questions about the 1998 plea predicate? Okay, if it's okay with the court, I'd like to go consecutively, so I'll deal with the 2003 predicate next. That was a predicate for assault and battery after a jury trial, so the issues are a little bit different. The problem, there's multiple problems for the Commonwealth's sufficiency here, but I'll start with the major one, and that is we know that the testimony at the 2019 ACCA jury was not the testimony before the 2003 jury. And we know that because the judge conducted a Martin hearing with this witness, and the witness at that hearing, inferably from what we can tell, she conceded that she had testified for the defendant at the 2003 hearing. At that hearing, she denied that an assault occurred. That's consistent with a contemporaneous police report that was filed in 2003, so it all makes sense. What she told the 2019 jury was quite different, and it was the only basis for the Commonwealth's evidence on this case. There was no jury instructions, there were no transcripts. The Commonwealth's only evidence was the testimony of a witness who testified differently in 2003. So it's similar to Perez in the sense that it's not probative of what happened at the 2003 trial. So in Perez, it was not probative of what happened at the plea testimony of a victim witness. In this case, for a 2003 conviction by a trial, by a jury, simply not probative. Nothing that no evidence there from which the 2019 jury could conclude beyond a reasonable doubt that the 2003 jury had convicted Mr. Mallory in 2003 of a violent form of assault and battery. We also don't have the jury instructions, which are another necessary element to meet the Commonwealth's burden. The 2019 ACCA jury had no idea what the 2003 jury was instructed on. If it was a violent form, if it was an offensive form, if it was a harmful form. And Judge Gilday acknowledged this. He said, I acknowledge that this could not be the basis of the conviction, but I'm going to let it in anyways because under Eberhardt, I can let in whatever would have been admissible, and I suppose this would be admissible. The Commonwealth, in its closing in 2019, also acknowledged to the 2019 jury that this could not have been the basis for the conviction. So it's different because there you have a plea and a jury trial, but similar in the respect that the evidence that the Commonwealth presented was simply not probative. In both the 1998 and 2003, at the end of the day, all we have is certified convictions. For 1998, assault and battery with a dangerous weapon, and for 2003, assault and battery. And it's very clear at this point under the case law that a certified conviction is not enough. The other evidence presented was simply not probative. This is an unusual case. We have a Martin hearing and a complete absence of any other evidence. So are there any other questions about that 2003 conviction? No. Okay. I can move on to the 2007 conviction now, which I acknowledge is a little bit more complicated to explain. Here we have, to meet the Commonwealth's sufficiency burden, 3 witnesses who also testified at the underlying trial in 2007 about an incident that occurred in 2005. The problem for the Commonwealth's sufficiency here is that in the Commonwealth's case in chief, there was simply no evidence about the theories that the 2007 jury was instructed. No evidence at all. They did not put in the jury instructions. What they did put in was testimony from 3 witnesses that were there that also testified at the trial in 2007. So at the end of the Commonwealth's ACCA 2019 case, Mr. Mallory moves for a required finding. That's denied. And in the defense case, so that should be the end of the story right there, because as part of the Commonwealth's sufficiency burden, it would need to establish to the ACCA fact finder, at a minimum, what theories the jury that convicted heard. That was not in the case at all. In the defense case, over objection, Mr. Mallory introduces the instructions to the 2007 jury.
In those instructions, the 2007 judge, the 2007 trial judge, instructed the jury that it could convict on a theory of harmful assault or offensive assault. Now, the clear legal implication of that instruction is that the 2007 jury heard evidence sufficient for either theory. And the implication of that is that they could have convicted in either theory. Now, as background, we know that the 2007 jury did not believe everything that the witnesses before it testified to. There were a number of not guilties returned in that same trial, including a not guilty for assault and battery and a not guilty for assault and battery with a dangerous weapon. And as a matter of law, of course, a jury does not have to believe everything that a witness says. They can pick and choose what parts of the testimony to believe. What we're left with, and what the Commonwealth is left with, rather, is testimony from 3 witnesses and no jury instruction. We know that they returned a guilty verdict, at least on this one assault and battery, but we have no information from which the 2019 ACCA jury could determine beyond a reasonable doubt the basis for the 2007 jury's legal conclusion. And indeed, we know that the 2007 jury would have been entitled to return a guilty finding on an offensive form of assault and battery, which we also know does not qualify as a violent ACCA predicate.
So it had, I hadn't realized that there were several charges in 2007.
Yeah, there were a number of charges.
Okay. So do we know that the conviction was based on the acts to which these witnesses testified in 2019? Do we know the basis of the conviction, the factual basis?
That was the Commonwealth's case, that was the Commonwealth's burden, and to meet that burden, they presented the testimony of these 3 witnesses. Now, defense counsel first argued in moving for required finding that the Commonwealth did not meet its burden, among other reasons because they did not establish what the jury was instructed. Defense counsel in 2019 also argued that based on that testimony and Mistretta and the legal principle that the jurors can pick and choose, they don't have to believe everything, we don't know if it was a conviction for an offensive assault and battery or violent, harmful.
But I guess what I'm asking, is it possible the conviction is based on some other act that we don't even have the 2019 witnesses didn't testify to?
Not as I read the transcripts,
Okay.
Your Honor. You know, part of the problem with this ACCA procedure is that, especially in this case, and this case illustrates it, they're essentially relitigating what happened back in 2007. You know, trial counsel received the transcripts of this 2007 trial quite late in the day, but she did diligently review the transcripts and, you know, in the defense case also read in part of those transcripts. So I believe that, you know, everyone was on the same page about the particular incident that was.
So if we accept the testimony of the 3 witnesses, just for purposes of discussion, why couldn't the 2019 jury find beyond a reasonable doubt that the 2007 jury must have convicted him of harmful battery based on this testimony, which does seem to be consistent with a harmful battery, not an offensive battery?
I agree that it could be consistent with either. So, and as the 2007 judge instructed the jury, it would have been consistent with either a harmful form of battery or an offensive form of battery. And there's simply no basis to know what that 2007 jury unanimously decided. Another problem with this procedure is that, of course, the 2007 jury is not required to decide unanimously. But I think the only way that makes sense under due process is if you're going to hang a conviction, a predicate, it needs to be a unanimous decision that that was a violent form of assault and battery. So that's, you know, yet another reason that's sort of hanging out in the background. But if this was a new trial in 2019, certainly the evidence that the 2019 ACCA jury heard would be sufficient for a conviction, a new conviction in 2019 on those facts.
I guess what I was asking was, would this testimony be sufficient for the 2019 jury to find that the 2007 jury must have found a harmful battery? I mean, because the acts described are that he pulled her from the bed and punched her in the face numerous times.
I agree with Your Honor that those are acts described. It's also true that the 2007 jury did not have to fully credit that testimony and could have credited other testimony, credited the denials, and said, well, I think this is at least a harmful, an offensive form. Indeed, the fact that the 2007 judge gave that offensive instruction suggests that there must have been, as a matter of law, sufficient evidence.
And if that instruction had not been given, would that undermine your argument?
I believe it would, Your Honor. And if
the judge had only instructed on that.
I believe it would, because that would suggest that the only theory would have been a violent theory. Or add that the Commonwealth did not.
And so it wouldn't have mattered in terms of which particular act, that they were unanimous about that, because that would have been the only theory presented to the jury.
I agree with that, but there's a bigger problem, is that the Commonwealth did not, as a part of its burden, put in the instruction at all. So at the end of the Commonwealth's case, the 2019 jury was left without any view of whether it was reckless, whether it was harmful, whether it was offensive in terms of the instruction. That is a basic part of the Commonwealth's burden. That instruction came in over objection in the defendant's case. And I think that's important here in the posture of how this appeal comes up.
Okay.
Unless there are any other questions, I'll rest on my briefs in the terms of the Eberhardt dictum and the constitutional issues that I've raised.
I think we're okay on this one. We're good? Yeah? Okay. Thank you.
Thank you very much.
So from Commonwealth on the sufficiency.
Thank you. Good afternoon. If it pleases the court, Arne Hansen for the Commonwealth, representing the Plymouth County DA's office. With respect to the gun issue, which I still believe is a very live issue in this case, the defendant's conviction for the firearm should not be overturned here, because the bifurcated jury did hear testimony and did see the certified prior convictions that demonstrated he was a convicted felon, and he was also convicted of numerous violent crimes as well as misdemeanors that were punishable by 2.5 years in the House of Correction. That, as a matter of law, would have made him a prohibited person at the time of his arrest, so he wouldn't have been able to legally acquire an FID or an LTC under either of those statutes. Therefore, he couldn't have been licensed. Now, this case is substantially different. So the Commonwealth has the burden here. We have to show that this was harmless error beyond a reasonable doubt. And there's a couple of cases that the SJC has decided in Bookman, they decided where there was uncontroversial testimony from the police officer that the defendant didn't have a license. That was enough to overcome the harmless error analysis. And there's a couple of cases out of this court that found similarly, and that's Encarnacion as well as Francis. In both cases, there was testimony that those defendants didn't have licenses. Here, the analysis is slightly different, and it's more akin to the more recent decision in Collins, where the SJC said one way to prove that an individual isn't licensed is by putting in their certified prior convictions. And that's what happened here. It just so happened that the defendant had a bifurcated trial, and that's for his benefit to shield the jury from his prior convictions, to make sure that that didn't influence their decision on the underlying case. But notwithstanding that, a jury did find that he was previously convicted of 3 offenses that would have made him ineligible to obtain a license, and that was supported by the certified prior convictions as it was in Collins. So therefore, that evidence was before the finder of fact. It just so happens that we have 2 separate juries.
A different finder of fact.
Correct. I think the issue...
So not the finder of fact, a different set of finders of fact. Doesn't that make a difference?
I don't think it does, because essentially they're asked to come to the same conclusion. In the Cologne case, the jury's asked, is this a prohibited person? Here's the evidence that you have. It's the certified prior conviction. In our case, essentially they're asked to come to the exact same conclusion with the exact same evidence. It just so happens to be a bifurcated trial. They're asked, is this person convicted of a violent offense, which would, as a matter of law, preclude them from obtaining a license, and therefore the Commonwealth can meet its licensure element. It's the same analysis, it just so happens to be a second jury. So the difference between this case and Ferreira is in Ferreira, the defendant was charged with possession of the firearm as well as a defaced firearm. And there was no ACC charges, there was nothing about subsequent, and the finder of fact never heard any evidence about the fact that he was a convicted felon because the issue wasn't before the court. But it was before the court here. I would ask that this court treat the defendant's trial, despite the fact that it was bifurcated, as one continuous process.
But they're two juries, right?
Right.
So if the defendant's tried for a separate crime and now everyone's smarter because Bruin came out and they know that what the Commonwealth's burden is and they put in the right evidence, then you can come back and say, well, because this separate jury found that he wasn't eligible to have a license, it's harmless beyond a reasonable doubt in this trial?
Yes. So the issue is it was presented to the jury, the same evidence.
It wasn't presented to the jury that returned the convictions.
Correct. Not to the first jury, but it was presented to the jury that was asked to evaluate the very specific
Keep
question.
saying the jury. I think you need to say first and second.
Oh, sorry, it went before the second jury.
Okay.
And my argument is they're asked to evaluate the exact same issue. Was this person a convicted felon? That's what the jury had to consider in Cologne, because the testimony, the evidence there was he's a convicted felon.
In the charges before the second jury were different than the charges that were addressed by the first jury, correct?
Yes, that they had to deal with the subsequent offenses.
So how does the second jury's verdict somehow validate an error or erase an error that occurred in the first jury trial?
Because the problem that the Commonwealth runs into is that the issue was never presented. And here my argument, it was presented, it was just presented in a different way.
Okay.
All right. So moving forward with respect to the ACC trial and whether or not the Commonwealth presented sufficient evidence to support the 3 prior violent felony convictions. Here, the Commonwealth had the burden of demonstrating that these were intentional harmful acts rather than reckless acts. As the Ashford and Perez cases established, reckless conduct wouldn't suffice to prove that a defendant was convicted of a violent crime. Now, the way that the Commonwealth went about that is the way that Ashford and Perez, as well as Eberhardt, specifically say that we should do this. Anything that is admissible would have been admissible in the original trial would be admissible at the ACC trial. So certainly testimony from the victims or witnesses would have been admissible at the defendant's trial, initial trial. I don't think it matters that the first trial was the first conviction was the result of a plea, because the standard evaluates whether it's admissible at the original trial. And in Ashford, the court specifically held that the evidence that could be considered goes beyond the Shepard documents, and the Shepard documents pertain to transcripts of that original colloquy. So I don't think in this case we're limited to that information. I think the Ashford case makes that very clear. We can consider things that weren't maybe necessarily before the court at the original convictions, or at the original pleas, or at the original trials.
It might be admissible, but how is it probative of what he was convicted of back in, let's start with the plea, 1998, what he pleaded guilty to in 1998?
So that's where the testimony of the witnesses becomes important, because they shed light on the specific circumstances of the crime as it occurred. Those would have been the individuals.
But he pleaded, so how do we know what he pleaded to?
Well, with respect to that, you would give, during any type of plea, you would give a submission of, you would read as a version of the facts. Presumably, generally speaking, my experience, this is an ADA reading from the police report or grand jury minutes, and they're summarizing from that. With respect to the 1998 case, you had Lieutenant Banaka, who testified at the subsequent trial in 2019. He would have he wrote the initial report. It's inferable that the ADA who handled that plea in 1998 would have read directly from Lieutenant Banaka's report when they read the facts into the record. There's no reason to believe that there would be a difference between his testimony 20 years later. Inferably, he would have also reviewed his report to refresh his recollection.
Proof beyond a reasonable doubt.
I would argue.
Lots of things can happen at a plea hearing, and the prosecutor could walk in and just, you know, give his or her own summary, right? Might not be as accurate or necessarily include the same details that might be in the police report.
No, all right, that's fair.
Yeah.
Now, the other side of it is...
So Justice Shin's point, it's fair, so if you can infer either one, where do we go with that?
I think it's important to look at the actual fact patterns here, because the case law holds that if it's inescapable that it's one and not the other, then there's no prejudice and we can move forward. And I think that's clear here. With respect to the first incident where the defendant gets pulled over by the police, he then stops his car, he waits till the officers get out of the car so that they can initiate their stop. He then reverses into them as they're getting out, almost strikes the officers. The officer was able to hold himself onto his car, and then he escapes. Now, I would say that fact pattern is very similar to the Perez case, in which this court found that when Perez was waved down by a different officer because he didn't have a license and he wanted to pull him over, he almost struck those officers. The court found that that was an intentional act.
That was conceded by the defendant in Perez, that it qualified as a predicate. I'm not sure that even if we accept the officer's testimony that it establishes whether it was harmful or reckless, to be honest.
There is another case that I cite, Garudi, it's an older case from the 90s, very similar fact pattern as well, where the officers are in pursuit of a defendant, he uses his motor vehicle to strike them in order to aid his escape. The court found that that was, again, intentional conduct.
It could be sufficient to convict him of harmful battery. The question is that what he pleaded guilty to back in 1998? Even if we accept that the testimony is exactly what was read at the plea hearing.
I think the question before this court is, how does the jury view it? I don't think we're limited to what was specifically said at the colloquy. And in my experience, I think it would be very rare for anyone at a plea to say, and he did this with the specific intent to do this, or where the Commonwealth would identify their theory of the case in what is essentially a very straightforward assault and battery, or assault and battery.
But the question is, what was he convicted of? Can I ask you about the jury trials? So the 2003 jury trial. The question is, what was he convicted of at the 2003 trial? Don't you agree that even assuming you could have put on live witnesses, that their testimony would at a minimum have to be consistent with what they testified to at the underlying trial in order to prove that's what he was convicted of?
I don't think that's the case. So there would have been, at the original trial, there would have been an independent witness who observed the information, and then that would have been the basis of the conviction. Here, I think the evidence was clear, and Tanya O'Brien seems to have changed her mind after being assaulted by the defendant a second time and then became a cooperative witness. I think the evidence is clear that it's inescapable that this is an intentional battery. She sees the defendant's mother and mistress in a car, flips off that car, that starts an argument, and then the defendant strikes her in the face. I don't see how that's anything.
That's not what she testified to in 2003.
Correct, but that is what she testified to at the ACC trial.
How is it probative of what he was convicted of in 2003? I mean, if I'm missing something, then please let me know, but I don't see how it's probative of what he was convicted of in 2003.
I would suggest that the underlying fact pattern didn't change between what happened in 2003 and what happened in the testimony in 2019.
Might have changed, but did the jury hear that same fact pattern in 2003? Isn't that the question?
I think it's for the ACC jury to determine whether or not this is a violent crime.
Can the
It's the question
Commonwealth,
before them.
So for example, then, let's say in hypothetically, the plea or the 2003 was certainly not a violent crime as in terms of what that jury heard and what that jury decided. You're saying that then another jury years later can say, oh, that actually was a violent crime, and it's going to be a predicate offense. That can't happen, right? I must have misunderstood you.
I think where the evidence would have been admissible, I think it's something that the second jury can consider at the ACC trial.
Just let me make sure I have this right. So a second jury at ACCA trial could determine what happened 4, 5, 10 years ago was actually a violent crime, even though the defendant pled guilty to a nonviolent crime, or the jury decided that on a theory, hypothetically a special verdict on a theory, and came back as reckless instead of violent. That would be okay?
No, and that's fair, but I think.
Okay, good.
My point is, again, with these fact patterns, they're very clear. Like in Perez, there's 2 examples of conduct that could be either reckless or intentional, where Perez resisted arrest on 2 different occasions. In one of them, he elbows an officer and tries to get away, and then another one, he throws a door into an officer as he's trying to escape. And I think in the Perez court said this could go either way, and it's not clear, and I don't think we're in that situation here. I think it's inescapable that if someone, for whatever reason, provokes you, and I'm not blaming the victim here, you then escalate it with an argument which ends in him striking her in the face. The only way that can be interpreted is as an intentional harmful battery.
Okay.
can the Commonwealth...
I interrupted, Justice
No,
Shin.
you didn't. Thank you. Can the Commonwealth put on witnesses at the ACCA trial who did not testify at the underlying trial?
I think the case law is clear that anything that would be admissible at the original trial would be admissible at the ACC trial.
So then the defendant could put on his own witnesses at the ACCA trial. So now we're having just a whole new trial on the underlying charge, on their underlying conviction. Is that what was intended by the Eberhardt dictum?
I mean, the Commonwealth has to prove that it happened. Okay. And the way that it proves that it happens is by putting in these witnesses. The defendant certainly is entitled to put up a defense.
Okay. All right. So I think your answer is that, yes, you can have a trial within a trial, is what you're saying, if I'm understanding your answer correctly.
I don't think it's an issue that's been addressed by the case law, but I don't see anything that would prohibit it. That's probably why we're here today.
I think it's going to happen.
Right.
All right. Thank you. Additional follow-up? All right. Thank you very much. All right. Well, we're a little deja vu. We'll go to the next chapter of your client's situation.
May it please the court, Matt Spurlock for a la MALLORY. 50 years ago in Frank's...
I'm sorry to interrupt, but I should actually read the number of the case into the record before we start. Same parties, but the number of the case is 2025-0069. I apologize for interrupting. Thank you.
Thank you, Your Honor. Matt Spurlock for a la MALLORY. 50 years ago in Frank's, the Supreme Court warned that the warrant requirement would be reduced to a nullity if the police could rely on false allegations to demonstrate probable cause and, having misled the magistrate, were able to remain confident that the ploy was worthwhile. That is exactly what happened here. The new trial motion judge concluded after an extensive evidentiary hearing that Detective Graham's averments about a controlled buy were recklessly false, requiring excision of false statements from the affidavit about a controlled buy. Now, that ruling is well supported by the evidence, and the Commonwealth does not challenge it in this procedure.
How do we know that the actual date of the third controlled buy was April 14th?
We know that because the drug buy locker evidence receipts that were first disclosed to post-conviction counsel in March 2023 revealed the precise dates of those buys.
Okay, that's what I was wondering, if it was based on that. But wasn't there testimony from Detective Donahue, at least, that the evidence isn't always logged in on the same day as the buy?
Donahue said sometimes that happens very infrequently. At the new trial motion hearing, Graham testified that extensively that it happened on April 14th.
On April 14th.
And so, you know, all parties are in agreement that eventually we got to a place where we're all in agreement that it happened on the 14th. Judge Gilday also ruled that it happened on the 14th. The Commonwealth makes no argument otherwise. They certainly have all the information where they could have come forward and said it actually happened on a different date. So the consistent testimony, but post-conviction counsel first learned that in March 2023. Prior to that, the Commonwealth resisted even an evidentiary hearing on the Franks motion under the theory that it could have happened on some other date, right? And that theory turned out to be completely baseless. The motion judge correctly went on to address staleness. And he correctly found that without this third controlled by, the execution of the warrant and the warrant itself was stale. And this is consistent, actually, with Detective Graham's own considered view. He thought, and he twice testified to this, first in 2017 and later in 2023, that he needed that third controlled by, because without the by, the information that he had in his affidavit was no good. There were two warrants in this case, one in April 1st and one in April 15th. The difference is this third controlled by that turned out to be based on false information. It was made up, and so it was properly excluded. Without that, all we have are two controlled bys 9 days apart. Now, to overcome staleness in this context, the Commonwealth realized, and Judge Gilday correctly recognized, that the Commonwealth would have to rely on the continuous conduct exception. That continuous conduct exception simply does not apply to two controlled bys over 9 days, and none of the cases that I've seen or that the Commonwealth site supports anything like that. Now, the Commonwealth's brief says this case is like Rice. I've explained in my brief that Rice, we have 14 months. The other cases I've looked at, we have continuous conduct, 4 bys, 6 bys. There's always something like that. I've never seen anything, and certainly nothing was cited, that anything like 2 bys over 9 days to constitute continuous and protracted conduct. Without that, what we have is the last good information, the last non-materially misstated information is controlled by, at best, on March 31st. And we have an execution of the warrant on April 20th, and the warrant was issued on April 15th. Now, whichever of those dates the court wants to consider staleness, it was stale. The correct date, as Judge Gilday ruled, was the day of execution. That, after all, is the date of the constitutional injury. The case law supports that, but you also obviously have to have non-stale information on the day of its issuance. It was also stale on the day it was issued, April 14th, as Detective Graham conceded. So unless there are any more questions on staleness, I'll move on to the other issues. Okay, so the new trial motion judge went on to, had this been a pretrial motion, this would have been the end of the story. All the evidence in this case was the fruit of this buy that was based on a warrant with recklessly false information. That evidence would have been excluded, and the Commonwealth would have not had a case here at all. But because this was a post-conviction context, Judge Gilday went on to consider whether Rule 30 afforded the defendant a remedy. Now, the SJC in Ramirez made quite clear that in the post-conviction context, Franks is a viable prey for relief. And that's exactly what the defendant did here. He raised the Franks issue, especially with something that had been concealed by the Commonwealth in the post-conviction context. But Judge Gilday went on to consider the issue under various frameworks under Rule 30. He considered it under ineffective assistance of counsel, and he considered it under newly discovered evidence, and then he considered it under Rule 30's general rule, the general principle in the interests of justice. Now, beginning with IAC, Judge Gilday concluded that ineffective assistance does not turn on what constitutes reasonable pretrial diligence. That was legal error. The cases are quite clear, and our cite Tavares, but many cases recite this, that trial counsel has a duty to make reasonable investigations or make a reasonable decision that make reasonable investigations unnecessary. There was also a factual error in that part of Judge Gilday's opinion, because he said in that part that there were only, he said there was extensive usage on the relevant dates and multiple incoming calls. Now that is a misreading of the record. In the Franks portion of Judge Gilday's order, he correctly recognizes that, for example, on April 14th, we only have one incoming call.
Right, but according to the affidavits, the defendant told trial counsel that none of the buys occurred, not just the April 14th buy. So then trial counsel pulls the phone records, which shows multiple calls, at least on the first day. 82 calls, I believe it was. So given that, why isn't it reasonable for trial counsel to assume that the defendant wasn't telling him the truth?
I think you have to look at all 3 days. So we have March 31st, also just a handful of calls, and you have April 14th, just a handful of calls. I don't think it's reasonable on that basis to throw your hands up and say, I'm done with the investigation. But even if the court disagrees with me, even if the court thinks that that was a reasonable course to take for trial counsel to stop the investigation of what turns out to have been quite a viable Franks motion with information that was readily accessible, at least the first part of that information, through a public records request, there is the newly discovered evidence doctrine is a totally separate basis for relief. Now, under that's sort of the flip side, right? The flip side of ineffective assistance of counsel.
It was available.
Excuse me?
There was the newly discovered evidence has certain preconditions.
Sure, it does. And some of it was available. So this public records request made it clear that one of the detectives, Detective Donahue, was not working on April 14th. It turns out, however, that that was enough to allow the Franks motion to be heard, to get an evidentiary hearing. At the evidentiary hearing, that was not enough to sustain the defendant's burden on the evidentiary hearing. The information that allowed an evidentiary hearing ruling from Judge Gilday on Franks was that this new information that for the first time the Commonwealth disclosed at the evidentiary hearing, far more detailed payroll timesheets. And those payroll timesheets were not disclosed when post-conviction counsel filed public records requests. Those more detailed timesheets show that actually Detective Donahue was working on April 14th. He was working on something called overtime court time. The problem for the Commonwealth is that he was only working until 1:07 p.m. that day, and he wasn't working after that. There were no calls coming in then, and so that didn't end up, helping the Commonwealth. But that was the essential piece of newly discovered evidence that was not reasonably discoverable through reasonable pretrial diligence, as illustrated by the extensive discovery fights that happened in this post-conviction motion. Post-conviction counsel again and again asked the court, asked the Commonwealth to disclose what they could about the timesheets, about information, and it was consistently denied, finally turned over. I don't think that the court can find that that was reasonably discoverable through reasonable
Well, it could have been, part of the question is whether or not they could have been asked for earlier.
Well,
now, the fact that there was impediments, and that really goes down to the third issue, which is the Brady issue, right? That goes into that one. But
post-conviction counsel certainly asked for it in the public records request in 2020, and what he got was not these more detailed records. What he got was, just a very basic timesheet that turns out to not accurately reflect what happened later. But in any event, if the court concludes that Mr. Mallory's claims somehow fall through the cracks of these two doctrines, Rule 30 always provides a ground for post-conviction relief in the interest of justice. And that is what Epps teaches, and what Brescia says, what Rosario says. These doctrines that we have, the doctrine of ineffective assistance of counsel, the doctrine of newly discovered evidence, there are specific instances of a more general rule. And the more general rule is that the interest of finality must yield, and that's quoting from Brescia, in the interest of justice. this is a situation where we have, from the very beginning of this case, police misconduct that is the basis for the only evidence in the case. And the Rule 30's interest of justice analysis certainly applies here.
But
Now,
you're
Judge Gilday,
relying on cases that involve trial errors. And your claim isn't going, other than the Brady issue, your claim doesn't go to, it's not a claim about the trial itself. And in Ramirez, the court said that the defendant's grievance lies in the denial, and Ramirez was the one case I found that was procedurally analogous, a little bit different. But the court said the defendant's grievance lies in the denial of the motion for a Franks hearing, not in the denial of a motion for new trial, and then affirms the denial of the motion for new trial. So what do we do with that?
well, Ramirez went on to order a post-conviction Franks hearing, and that post-conviction Franks hearing was held, and the judge at that post-conviction Franks hearing determined that actually he didn't have a viable Franks claim. That was affirmed by the appeals court in 2020. But the clear implication of that is that if there had been a viable Franks claim in the post-conviction context, that goes under Rule 30.
I don't think it's an implication, because then in footnote 13, the court says, we note that this search warrant will be voided if the defendant proves his allegations in the course of the evidentiary hearing, which we ordered today. In turn, the evidence seized would have to be suppressed and the defendant's conviction set aside, but not under any Rule 30 analysis, because they affirmed the denial of the Rule 30 motion.
Well, there was a different basis for the Rule 30 motion in that case. And so in my best reading of Ramirez is that they denied on one basis, but allowed a post-conviction procedure, whatever you want to call it, Rule 30 or any other name. It was a post-conviction Franks procedure. Now, certainly just...
You read this footnote to mean that if there's a post-trial Franks hearing where the defendant succeeds in proving his claims and that the remedy is that the warrant, and that voids the warrant, that the remedy is that his convictions be set aside?
The remedy would be a new trial, and if all of the evidence in that case was the fruits of an unlawful warrant, then yes, his conviction would be set aside, but the remedy is a new trial. And I think you can see
First
that.
a new trial, and then an evaluation whether or not the Commonwealth can go forward.
Yeah, just a standard post-conviction Rule 30 procedure. You know, I agree with Your Honor that the cases that I cited have to do with trial errors, particularly, but it is not in the interest of justice to have a trial based on evidence that was unlawfully obtained and a warrant based on police misconduct. I don't hear the Commonwealth argue otherwise, and I will note that the Commonwealth actually makes no argument on this, either on newly discovered evidence or on Rule 30. Now, to get back to Judge Gilday's discussion of Rule 30, he distinguished EPS. In the judge's view, EPS was different because that involved scientific advances, whereas this case involved, in his words, tangible items or information. That is really a distinction without a difference under Rule 30's interest of justice. Indeed, the interests of justice weigh more heavily where the Commonwealth, here the police department, is withholding information in its own possession. After all, EPS, you know, the advance in science cannot be attributed to the Commonwealth there. Here we have the Commonwealth with an officer that recklessly misstated material facts in an affidavit and managed to obscure that from defendants until years after a conviction. So it makes little sense to distinguish EPS in terms of the interests of justice analysis.
Let me just ask you, because your time is up, what do you say about the fact that the judge determines that this can't be a Brady violation because there was no knowledge of the quote-unquote negligent represent, because he refers to this more as a negligent type of misconduct rather than intentional.
So that's the Brady claim, and I think that's a misreading of the law of Brady. First of all, Brady does not require an intentional, recklessly, police misstating information by a police officer, recklessly filing reports, and I've cited cases, look to my reply brief especially to that effect. That's just a complete misunderstanding of the law. Brady is also instituted a no-fault. It's essentially a no-fault framework. It doesn't matter if the prosecutor knew. It doesn't matter if that the detective was withholding. But in terms of the detective's conduct, it doesn't matter if the detective's conduct was reckless or intentional. Judge Gilday necessarily did not back off his finding on Franks that this was at least recklessly misstatement. Indeed, that's what the whole Franks holding is based on. And again, the Commonwealth does not challenge that on appeal at all, as far as I can see.
You answered my
If there are any
question.
more questions or rest on my briefs. Thank you very much.
Good afternoon. The defendant's motion for new trial rises and falls on whether or not his trial counsel, Attorney Spillane, was ineffective for failing to investigate the claims that the defendant raises. So the defendant claims that he told Attorney Spillane that, and Attorney Spillane appears to agree, that none of these controlled buys happened and certainly didn't happen on those dates. And as a result of that, Attorney Spillane got the phone records for the phones that were alleged to have used during these buys and reviewed those phone records. And after that review, I think it was reasonable to infer that the defendant's claim was unsupported. On March 22nd, there were 82 incoming calls to the defendant's phone number that was used on that day of the buy. And most of those calls were 1 to 2 minutes. On March 31st, there were 9 calls, and this is the second phone that the defendant is using. So there is substantially less volume, but what stands out here is that it's a second phone, and this court has long agreed that having multiple phones is indicative of drug distribution. And then there are 25 calls on April 14th. I know that's been excised, but that's certainly something that Attorney Spillane would have considered. So Attorney Spillane examines the defendant's claim and sees that there's a high volume of 1 to 2 minute calls on each of the days on 2 separate phones. I think at that point it was not manifestly unreasonable for him to decide, what you're telling me doesn't make sense, and I'm not going to investigate this further because there's no reason for me to do so.
Okay, so the judge determines that that conduct did not fall, further investigation did not fall below what one would expect from an ordinary fallible lawyer. But we now know that there was a problem with the search warrant.
Right. So with respect to the ineffective assistance of counsel claim, the issue is whether or not that would have been present at the time rather than informed by hindsight. So we know that post-conviction counsel obtained a bunch of records, and Detective Donahue's timesheet does not match up to when this control buy would have occurred. Mm-hmm. But that's not something that would have been reasonable for Attorney Spillane to have investigated further. So in order to obtain these records, he would have had to file a Rule 17 motion pursuant to Dwyer. And he'd have to have a good faith basis to show that—
I see your point, but I'm more interested in how the Commonwealth wants to approach the situation where there's no disagreement or dispute that there's no concrete support for this third control buy.
I would suggest that isn't in fact the case. I mean, when both officers testified, Detective Graham testified at length about how he did these control buys, and he stated, I never do these by myself for safety reasons and any number of reasons. He was adamant that Detective Donahue was with him on that date. Detective Donahue then took the stand and affirmed that. I think what happened here is they couldn't explain 8 years later why his timesheet didn't match up. I think it is just as inferable and substantially more likely, and I don't have any evidence to support this because we're just left with the record that we have, that Detective Donahue made an error on his timesheet rather than this buy didn't happen.
Let's stick with what we do have on the record and not what might be a reasonable explanation.
Right. So that goes to, whether this was deliberately withheld, and I don't think the record supports that contention either.
The judge doesn't say that. Right?
I'm not sure I understand.
The judge doesn't say that it was deliberately withheld.
No, he said that the conduct was potentially reckless. Now, with respect to this, does it make any difference in the defendant's conviction? And I would argue no. Like, The defendant suggests that this would be a strong basis of impeachment at trial to suggest that the underlying buys didn't happen, so therefore this Detective Graham has credibility issues and his conviction should be vacated. I think it's important to look at what Detective Graham testified to at trial. He testified that he was familiar with the defendant, he testified to the layout of the apartment, that he was the lead investigator, that he got the key from one officer and handed it to another one, that he walked inside the apartment, saw the birth certificate in the safe, found the dog tags, and saw some of the scales, some of the indicia. So his testimony certainly doesn't, it's part of the case, but it's not the foundation of the case. A different officer finds the gun, a third officer finds the drugs. Nothing that he really testified to at trial sealed the deal for the Commonwealth in this case. But more importantly, if his credibility were to be challenged by the fact that, hey, did you make up that third buy? Did that never exist? That opens the door to the defendant, that opens the door to all of the other controlled buys. So the Commonwealth would be able to rehabilitate those, and those would come into evidence. So then we do have two buys that weren't thrown out by Judge Gildea 2 months or a month before the search warrant. The defendant's entire defense at trial was, I don't live here anymore. I don't know anything about this place. My brother-in-law lives here. I don't know anything about the drugs. By impeaching Detective Graham with this issue, you're essentially introducing additional evidence that completely undermines that defense. You're introducing evidence that links him to that location and to drugs at that location on 2 other days.
So these arguments are relevant to the Brady issue, but in Ramirez, the court said, although the newly discovered misstatements in the warrant application did not warrant a new trial for this reason, which is that it could only have been used as impeachment evidence at trial. But while it doesn't warrant a Rule 30 relief, it did warrant a Franks hearing. And then in the footnote, they say that if the defendant proves his allegations, he's entitled to relief in the form of voiding the warrant, and then his convictions must be set aside. So why aren't we bound by that?
So that would lead me into the first argument that I make in my brief, is that even if the last controlled buy is excised from the search warrant, there's still probable cause within.
Okay, but I don't mean to cut you off, but if we conclude that the judge was correct, that once you excise the last buy, that the warrant is now stale, would you agree that Ramirez entitles him to relief?
That's fair.
Okay.
Thank you.
So, which leads me into my last argument. So what Judge Gildea failed to consider is there's more than just 2 controlled buys here. So we have the controlled buy on 322 and then 331. What's important to consider here is that there's a 9-day difference between those. And we see that over, let's say, a 2-week period that the defendant is distributing drugs from that location. That is then bolstered by the informant's information. Prior to the control buys, he tells the officers, I have bought from this person, his name is Parad, he sells me narcotics from this location, I call him on this number, and this is where I go to retrieve those narcotics. That doesn't appear to have been considered by Judge Gildea. Now, it's at that point, it's just statements of a confidential informant, and it's not corroborated, but that's where the controlled buys come in. The controlled buys can buttress those unattested to statements, where the control buys are exactly consistent with what that CI informed the officers of. Then there's additional information that's in the 4 corners of the search warrant that supports that this was ongoing activity. The officers reference their knowing that they know the defendant, that they are familiar with his reputation, that they are familiar with his nickname, Parad. And then they go further and say he's been arrested for drugs in the city before. We then also have the fact that he has 2 separate phone numbers, which is again indicative of ongoing drug distribution. Drug dealers have multiple phones. So I think there's more than just those two controlled buys. On top of that, Judge Gildea appears to consider the date of execution date. Now, the case law is very clear. Once a warrant issues, the officers have 7 days to execute the warrant. Here, the warrant issued on April 15th, and they executed it within 5 days on April 20th. That's within protocol. I think the date that the court needs to consider is the April 15th, which is the day that the magistrate determined that there was probable cause. It shouldn't make a difference whether they executed it the same day, 1 day, 3 days, 4 days, 5 days, 6 days, 7 days. If they executed it 8 days, obviously that violates the law. But any day within that 7-day period should be treated as the same date. So what we have is the last control by on April 31st, and then the execution of the search warrant, or the search warrant being signed on April 15th. So that's 2 weeks and a day. That is consistent with case law that I cited that holds that a 2-week gap wouldn't necessarily make the issue stale. And that's the Connolly case, which I cited in my brief, as well as the Cruz case. Both of those were 2-week gaps. And certainly this court has dealt with other cases where we've had much larger gaps. There is no specific cutoff. It just needs to be considered in the totality of the circumstances. So within that context, when we consider everything together, I don't think that a 2-week gap would necessitate finding that this warrant was stale when it was issued. If there are no further questions, I would rest on my brief.
Thank you both very much. We've kept you, both of you here for quite a while, and we appreciate you answering all of our questions. Thank you. So, the court will stay in recess.
All rise.